Judge.
Good morning, Judge.
Good to see you.
Good to see you.
Wish we would see each other in different circumstances. You need to come by unrelated to this case sometime.
Okay.
All right, let's figure out what we are going to do. We have the Stargell motion about probation we need to work through. And then we are handling, I think it's the Willie Moses plea. Mr. King is on his way, so we can wait on that. Mr. Moses has been brought up, Deputy Gordon, so he's here. And then remind me the second plea we're taking this morning. Pendleton, yes. I don't see him yet. Okay, he ought to be here. His lawyer's announcement last Thursday, in the new reality of it's not going to be a probation plea, if it's a plea, was my client. He had a conflict. Counsel did for Monday, Tuesday-ish, but this day worked, and his client was supposedly flying in from whatever state is home. That was going to be staying with relatives, such that being here on Thursday wasn't going to be an issue. So I don't know if you and, is it Mr. Cook?
Yes, sir.
Have you all connected? Okay. All right. Well, hopefully they're on their way. Then Mr. Rousey, the only case we can go forward with right now is Stargell. So if you want to get your clients in here, I would like to start. Thanks. Stargell,
Oh, that's the TV.
Judge, can I?
Oh, no, the attorney. The attorney.
Mr. Rousey, Rowsey, and co-counsel is Steele, as in Brian. Your buds. And here comes some help.
Okay, good, thank you. But I'm still happy to be here.
Good. Don't let the smile fade.
Is that right?
Yes.
Tom. Tom.
All right. Are you ready?
Correct.
Okay.
have two of these. You need to miss a couple.
Just ask to get those emails. Taking the name of two.
Okay.
So.
I think you need to step out.
Does the monitor always see them?
It does, but that's because I will broadcast that if someone is testifying. I'll add that screen. We need to if you log in, ultimately, we'll figure it out. But when you can log in, if you have Zoom running right there, you'll be able to see it. Yeah. Yeah, no, 100%. Right. Because Karen has sort of worked through that, but we leave that there because that captures. Ms. McGillicuddy, are you ready?
Yes, I was just briefly speaking to Mr. Rousey about this. We have two witnesses and I believe they have witnesses they'd like to put up as well. And so my question was, obviously my first witness is here, it's my investigator, but my second witness, I can ask to step out into the hallway for sequestration purposes if they don't hear what the first witness says, if that's.
It's really up to the two sides. This doesn't strike me as a rule of sequestration type proceeding. That said, that's not my call. I will certainly enforce it if one side or the other wants potential witnesses to not hear what's going on. I don't think there's a lot of surprise here. It's more of a, what were you thinking and what was the impact and how does it align with conditions of probation?
I agree.
So then we don't need to do that. Okay.
We'll leave it as is. Great. Okay. Well, let's get on the record then. This is 26 SC 002043, State versus Stargell. And we are here today to address the state's emergency motion to revoke probation. Mr. Stargell had a plea date in late April, at which time he entered a plea and received a sentence of 5 years probation pursuant to the First Offender Act. One of the conditions of his sentence was that he have no contact directly or indirectly with Ms. Hicks or any of her family. And the day of the plea and sentencing, there were a couple of social media posts that are alleged in the motion that the state is construing as effectively being violations of what I tried to make a pretty clear directive to Mr. Stargell and his family, because I explained to Mr. Stargell that contact through others to Ms. Hicks or her family would be inconsistent with that condition as well. The state's filed its motion. We are getting together only in June because we have busy lawyers on both sides. We've been trying to schedule this for a while, and there were conflicts on the state side. There were conflicts on the defense side. It wasn't because I didn't feel like it was urgent or unimportant for either side to get clarity as to what can and cannot happen as we go forward and what consequences, if any, flow from the two posts, I'm calling them, that occurred here in the courthouse or the courthouse steps immediately after the plea and sentencing. That's what we're going to work through this morning. Ms. McGillicuddy is here for the state. We have Mr. Rousey and Mr. Steele here for Mr. Stargell, who is here in court. And I'm ready to proceed. Before you get into substance or calling any witnesses, is there anything procedural you want to clear up that I've misdescribed? And I want to be clear, I'm not making any findings of fact. I'm sort of summarizing what the motion said and I think the posture that we're in.
No, Judge, I think you summarized state's motion effectively.
Okay. Mr. Rousey or Mr. Steele, good morning to both of you. Anything you want to add, again, just in terms of the procedural posture?
No, Your Honor.
Okay, then we're good. It's the state's motion, so if you want to call your first witness.
Absolutely. State will call Assistant Chief Investigator James Spear.
Your Honor, can we invoke the rule?
So no, because I guess before you got here, Mr. Rousey and Ms. McGillicuddy and I talked about that, and Mr. Rousey agreed that given what this is all about and the need to describe it the right way, the fact that the state's allegations aren't they're all out in the open and the postings are what the postings are. We agreed that this wasn't the type of proceeding where that would be necessary. And so Mr. Rousey said, I'm okay with the state's witnesses staying in here. And Ms. McGillicuddy said, I'm okay with the defense witnesses staying in here. So coordinate with counsel. We're going to let everyone stay right where they are. And if you would let Deputy Gordon swear you.
You raise your right hand. Do you swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You are, can you state and spell your name for the record?
James Spear, JAMESSPEAR.
Mr. Spear, where do you work?
I work at the Fulton County District Attorney's Office. I am the Assistant Chief Investigator of the Special Victims Division.
And how long have you been working for our office?
Since February of 2018.
And prior to that, what's your background?
So I previously worked at Atlanta Police Department for 7 years and a little bit of change. During that time, I primarily was assigned to a field investigation unit. We specialized in undercover operations in relation to firearms, narcotics, prostitution, robbery, theft, and other various felonies.
And is it fair to say that in both your prior experience and your experience now at the district attorney's office, you know, it's within your job function to get search warrants, returns, cell phone records, things like that?
Yes.
All right. And is this the first time you've ever gotten a search warrant for a cell phone?
No.
Or for, not a cell phone, let me be clear, a Meta Instagram account?
No.
And when you received the search warrant return information, have you reviewed those in the past?
Yes.
Okay, and by those I mean the information that you received from Meta/Instagram about whether it be a Facebook account, an Instagram account, things like that.
Yes.
I want to start off. So let me ask you, are you an investigator that would assist me in the district attorney's office as deputy district attorney of crimes against children?
Yes.
Okay, so you'd be my investigator, sort of.
Yes.
All right. So, are you familiar with this case that we're here to talk about today, this historical plea that happened on April 22nd?
I am.
Okay. And are you part of what we would call a courtroom team for me as a deputy district attorney? Being you a victim advocate and an attorney usually? I
am.
Okay. And so on the date of the plea, which was April 22nd, 2026, did we as a kind of courtroom team begin receiving that evening screenshots from the victim's family about things that they were receiving as far as online?
We did.
Okay. Let me start, I think, here I'm gonna, Judge, do I have permission to approach the witness?
You do. Counsel on both sides has permission to approach all the witnesses to deliver things. Once you've delivered things, if you'd retreat to podium or counsel table, you don't need to check with me again.
Okay.
It's almost like a volunteer, it's just a call. And this is what you said. Yes, absolutely. Good. It starts at page 81, and if you go to the last page, you can already find it. That's the last page of something. Page 24. And then this is what some of you could get the record. Yes. Okay.
I know there aren't discovery obligations in connection with the revocation hearing, but are the materials you've got things you've not shared in advance with Mr. Rousey, or?
No, I have.
You have. So
A lot of them are in the record already in terms of the search warrant return. Those are things that are already filed. I just am kind of gonna walk through them, but the only additional item is something I sent to Mr. Rousey.
Okay.
All right. And AC Spear, I'm showing you what's been pre-marked as state exhibits 1, 2, and 3. Can you take a look at those and tell me if you recognize those?
I do.
Okay. And what do those appear to be?
Exhibit 1 is a post by Miss Christy Penson Stargell. The background of the post and the layout indicates that it is on Facebook or Meta.
Is this what's exhibit 2 to your motion?
Yes.
Okay.
Exhibit 2 is a picture of Andrew Stargell, which is the Instagram account for the defendant. And it displays a picture of the defendant. To the left, defense attorney Brian Steele. To the right, defense attorney Tom Rousey.
This is exhibit 1 to your motion.
Correct. Sorry, Judge.
No, I'm glad you're renumbering them.
I'm sorry.
It's all right.
Should have numbered them. Go ahead.
Exhibit 3 is another Instagram post, but it is a screenshot with the handle name of max.harrison06. And it is a picture of the defendant and his parents. He has his arm around his parents on the Pryor Street entrance of the courthouse, 160 Pryor Street.
And just to clarify as to that third one, is that one's numbered the same, Judge? Just
1 for 3.
Just to be clear, does that, for the record, the screenshot that you are looking at, does that appear to be essentially a repost of a post of Andrew Stargell in the screenshot?
Yes, it's a repost. It's actually on the max.harrison06 page.
Okay. And do all 3 of those fairly and accurately represent what we received on April 22nd, 2026 in the approximate evening hours?
Yes.
From the victims?
Yes, they do.
Okay. But at this time, I'll move to tender states exhibit 1, 2, and 3 into evidence.
Defense, any objection to 1, 2, or 3?
Yes, I don't believe it's the right witness. I'm not gonna really have a problem with them getting in, but yes, I'll object to it coming in through this witness that he got it from somebody else. It would be hearsay and it would be due process, not constitutional confrontation clause necessarily, but a due process right to confront the witness.
These are items that were the byproduct of the search warrant that you served, or you got these from some other means?
These were first received from Mr. Luke Hicks, Claire's brother. And then through the search warrant, I was able to obtain exhibit 2 and exhibit 3. And there's one other additional.
But the exhibits that Ms. McGillicuddy is tendering now, 2 of them you got through the search warrant are actually just photos.
Yes.
Okay. Help me understand your objection to the photos if they're the product of a search warrant as well. And so we have someone describing what he thinks is in the photos. You can cross-examine him about the accuracy of identifying you with a victory sign in the photo. But why isn't there a sufficient foundation for the 2 photos?
I believe that, how is that coming in through somebody who gets a return? They need somebody from Meta or some business record exception or something better than this is what I got from another entity.
So I thought, and maybe I misunderstood. I thought that there was a business that Meta provided. These are things we normally keep in the course of business, et cetera, and that was submitted to you. That's not what's happened?
That what happened.
I don't, I'm asking you. I don't get in the middle of that flow.
I don't believe that I didn't see that happened, and it may change it, but I also think that 1, 2, and 3 is coming from a different person. It's coming from a brother of the alleged victim. I didn't hear it coming back from the search warrant.
You weren't listening closely. 1, you are correct. 2, yes, and 2 and 3, the photos also came as a product of the search warrant. That's what I just asked the investigator. And he said 2 and 3 photos were the product of the Meta search warrant.
I'm gonna hold on my objection. I believe that under grade GRIGG versus stage 372 Georgia Appeal 96, 2024 case. I have a copy if you want a copy.
I don't need a copy.
But I believe that it's the wrong witness.
Okay. Ms. McGillicuddy, I will provisionally admit 1 through 3, and then I'm assuming you're going to call a witness who can tie it up and address the concerns that Mr. Steele has raised. I'll add for the record that these 3 exhibits were attached to your motion, so I've already seen them. This is a non-jury proceeding. That doesn't mean the rules of evidence don't apply. So I'm not in any way saying that we don't need to work through the objection, but I'll provisionally admit them so you can discuss them with this witness, but they're not part of the record yet. other than they're in the docket because you filed a motion with them as attachments.
Yeah. So back to the ones that you have before you, that's how, is it fair to say that that's how our office becomes aware at first that there may have been a violation of probation?
Yes.
Okay, and so once we received those images, what did you then do next?
So then we began our investigation, and I was able to conduct a search warrant and have that signed on May 1st. But I was also able to speak to Mr. Luke Hicks and receive more information about his understanding of how he obtained photos and evidence.
And just to be clear, Luke Hicks is Claire Hicks's brother.
Yes.
And the son of Michelle and Jay Hicks.
Yes.
Okay. I'm approaching you, what's been marked as State's Exhibit 4. Can you tell me if you recognize that?
Yes.
Actually, I'm gonna give you 4, 5, and 6. Can you look at all 3 of those?
Yes. Okay.
Okay, and we're gonna move through these pretty quickly because it's straightforward. Tell us what Exhibit 4 is.
Exhibit 4 is actually the affidavit for the search warrant, which was signed on May 1st of this year.
And is that something that you prepare, based on what you know at the time, to give you a reason to seek a search warrant? For what exactly? What were you seeking a search warrant for?
Yes, in reference to the Instagram content posted by at Andrew.Stargell. And I used the date time span of April 22nd through April 23rd of this year.
So very narrowly tailored to sort of the time frame that we had become aware of.
Yes.
Okay, and then what's Exhibit 5?
Exhibit 5 is the actual search warrant document of the search warrant package.
Okay, and then what's Exhibit 6?
Exhibit 6 is the return, which was conducted on May 12th of this year. And it is composed of 12 pages from Instagram. And it also states that a USB was connected to this return, totaling in 1,258 pages.
Okay, and then I'm approaching you with what's been pre-marked as State's Exhibit 10. Is that appear to be the USB drive that's referenced in the search warrant return that we just talked about?
Yes, it is.
Okay, do all of those items, State's Exhibits 4, 5, 6, and 10, appear to be in a fair and accurate representation of the search warrant affidavit you prepared, the search warrant that was obtained, and then the search warrant return as well as the accompanying flash drive?
Yes.
Yeah, does any of that appear to have been altered in any way?
No.
Judge, I move to tender States 4, 5, 6, and 10.
10 is everything that Meta/Instagram sent, as opposed to just the particular exhibits that are provisionally admitted.
Correct, and just to be clear for your honor, the only portion, I'm not going through 1,200 pages for the
Good
record,
choice.
it's not worth it. But there are just a few things that I have separated as screenshots that I've already sent to Mr. Rousey and discussed with him. So that's just being tendered to complete the record as to what we received.
All right, Mr. Steele, any objection to the admission of 4, 5, 6, and 10?
Yes, sir.
And that is?
4 is an affidavit, it's for a search warrant. I don't see why that should come into this record at all. I would object to it.
Besides you not liking it, what is the basis of your objection?
Doesn't matter. There was an affidavit signed by this person. You shouldn't take his statements under issue. And I know you're the court, and I know you could separate everything from probative or non-probative, but I don't see how that is relevant.
Relevance, okay.
Let me finish. To this hearing at all in any manner, and it gives opinions of this person.
Okay,
I don't.
Exhibit 5?
Exhibit 5 is a search warrant. I don't object. Exhibit 6 and number 10 are the returns, and I'm going to have the same, have the same objections that I believe this is the wrong person. Number 10, first of all, seems like, and I didn't ever see number 10, but it seems like it may be too broad for the 2-day period, according to what I just heard this attorney say. That may not be true. I've never seen 10. but I'm
Okay.
objecting to 10. Number 6, which sounds like it's 12 pages that Mrs. Attorney deeming relevant. I believe that it is not enough to just have this witness here, that means somebody to say that this is a foundation being laid, and that's under the same objection in the same case that was seen.
Got it. Okay. Any response?
A couple, all of these documents, I'm tendering them at this hearing to perfect this record. They're all in the court's record, already as part of this case. Your Honor is who already reviewed the affidavit for the search warrant, signed the search warrant, and the search warrant return is filed into this case number. So I don't see how me perfecting this record here is in any way deviating from what we would otherwise do. The Meta Instagram search warrant return does have all of the necessary business record language. We routinely have our investigate, we're not bringing people from Meta here to tell us that what they put on flash drive and sent to us is the search warrant return. It's included in that. The 1,200 pages that are on that flash drive are for that narrow time frame, and that language is in the search warrant return portion that's printed and attached to the search warrant return.
Remind me the window, you already got it out through Investigator Spears' testimony, but what was the window for which you sought Instagram content?
It's the 22nd of April, 2026, which was the day of the plea,
Mhm.
to the 23rd of April, 2026, which is the following day. And
Okay.
that's only because the way Meta Instagram works is in UTC, not Eastern Standard Time. And so we just do a 2-day in the event that when we do the conversion of time, we're capturing the amount of time we need.
Okay, so I'll admit all of it. The only caveat I'll add is that Exhibit 10, one, it's a thumb drive, so it's not like physically it's in evidence, but insofar as the court reporter requires what's on the thumb drive to be turned into a digital file, that may need to be under seal in the docket, because Mr. Stargell is entitled to talk about other things on Instagram that aren't inconsistent potentially with his conditions of probation, and the rest of the world don't need to see those things. So if the way this record needs to be made is that what's on the USB drive has to be turned into a PDF or a series of PDFs, that needs to be under seal. If there's an appeal, Court of Appeals can see it and read it. If there's not an appeal, then it's just safely protected in the docket.
No objection or no issue with that, Judge, whatsoever.
Okay.
Okay, so we can set all of those to the side if you would, it seems fair. So once you got the search warrant return and the flash drive, describe to us how we just heard a question from defense counsel about the voluminous amount of pages. Why is that the case?
This is a pretty normal protocol for Meta, for Instagram. When they send the return evidence back, it's usually in a large format, in which this came in the format of a records page, preservation 1, preservation 2, as well as it kind of says linked media. You have to then go through that information and determine your evidence and separate it, because Meta does not actually separate it exactly for how you ask in a search warrant. You have to do that yourself. But it comes in a digital format. It does not come in a physical format. It comes in a digital format.
And included in those 1,200 pages are, IP address codes and, UTC time. Just if you could tell us, I know I've already said it, but why did they use UTC? What does that mean?
Yes. So UTC is universal time. So basically, when we're converting this to Eastern Standard Time, we subtract 4 hours to equate to Eastern Standard Time. But that time is designed for you to add or subtract hours depending on where you are around the world.
Okay, and just to be clear, included in those 1,200 pages also is a lot of data that is not relevant for our purposes, but it's just included as part of the standard protocol for Meta.
Yes.
Is that fair? Okay.
Yes.
And so, when you were reviewing this search warrant return to see if you could kind of, for lack of a better word, match up what was there to what we had been sent, were you able to do that?
Yes.
Okay. And talk to me about the posts that you were able to link up.
Yes. So particularly 3 posts in which the post I already previously mentioned, where it displayed the defendant, attorney Brian Steele and attorney Tom Rousey, the defendant and his parents. And also there's another picture with the defendant and his father, but the picture is taken from behind him, which is in front of the Prior Street entrance of the courthouse, in front of 160 Prior Street.
Okay, and just really quickly, when we're talking about, you said 3 different posts. I want to be clear about the difference between a post and a picture. So on Instagram, how does that work?
So when a person posts when a person makes a post, they can add multiple pictures. In this case, the defendant completed 1 post with 3 separate pictures. And you could also add verbiage to that, which there are 2 different sections where you can add verbiage to your post.
When you say verbiage, you mean like a caption?
Yes.
Okay. And so, in other words, if you were looking at it on Instagram instead of in a search warrant return, you would see the post, and then you could, for lack of a better word, there's like dots on the bottom that
Yes.
you can swipe through the pictures.
Yes.
But it's one comment section for that entire post,
Yes.
even though it contains more than 1 picture.
Yes.
Is that fair? Okay. So I'm gonna approach you with what's been marked as state's exhibits 7 and 8. Can you tell me what those are?
Yes. Exhibit 7 is a picture that's taken behind the defendant and what appears to be his father, and that is in front of the 160 Prior Street entrance of the Fulton County J3 court building.
Okay. And then what about 8?
And exhibit 8 is a picture of the defendant with his arm around his mother and father, and it's in front of the same entrance of 160 Prior Street on the outside of the courthouse.
And just to be clear, as part of that series, in the search warrant return, did you also see the other photo that we've already tendered of the defendant with his attorneys? And that was able to be matched directly to the search warrant return, like you were able to.
Yes.
That one.
Yes, it was all a part of the same post.
Okay. And what date was that post made?
That post was made on 4/22/2026 at 10:19 p.m. Excuse me, it's 6:19 p.m. in Eastern Standard Time.
Okay, and when you say 6:19 p.m., so if it's 22:19 UTC, the math here is you subtract the 12 hours to get to the 10 p.m. UTC, and now we have to convert UTC to Eastern Standard Time, and that's a 4-hour.
Yes.
Is that how you got to the 6:15?
Yes.
Okay, so this was done, just to be clear, on April 22nd, 2026 at about 6:20 or so.
Yes.
Okay, in the evening. All right, I'm approaching you with what I've pre-marked as State's Exhibit 9. Can you take a look at that?
Yes.
Tell me what that is.
This is part of the return from Meta in reference to these Instagram, reference to the Instagram post. And basically, these documents confirm that this is a post from the defendant associated with his email.
So are those the comments that were posted on, that would have been on the Instagram post that we were just talking about with those 3 pictures?
Yes, yes, these would have been comments in relation to the defendant's post.
And it's page, correct me if I'm wrong, 83 to 104, is that right? Of the 1,200 pages of
81
to, I think it's 104.
104.
Okay, so those pages are the comment section for this post, and they repeat under each image in that 1,200 pages because it's one post.
Yes.
So the comments are the same.
Yes.
Okay, and does that appear to fairly and accurately represent what was on that flash drive? It's just a printed version of what's on that flash drive of just that portion of the search warrant return.
Yes, it does.
Does it appear to have been altered in any way?
No.
This time we move to tentative.
So I want to make sure as a admitted non-Instagram person, when you're talking about comments, would you have obtained from Meta a photo that the account user posted or the user of the account? And you've explained why this account is linked to Mr. Stargell. Doesn't mean he posted on it. Someone could have been using his account, but his account, there's a photo posted on it, and then there are comments. Comments could be from other Instagram users, or comments are what the account user puts beneath the photo that he or she posts.
So the comments can be from the user and also from other users in relation to the post.
Okay, and does Exhibit 9 have comments from people who are not using the Andrew Stargell account?
Yes.
Okay. All right. Mr. Steele, there are 3 exhibits that the state is tendering now. 7 and 8 are photographs of your client, and then 9 is this collection of posts from the Instagram return that the state received pursuant to its search warrant.
I have the same objections, Your Honor, especially the comments.
Okay.
And when I say the comments, I'm referring to third parties that Meta has, who's not a representative here. Who, now we have their information in the record, and that would be number 9.
Right. Okay. I'll admit 7 and 8. I'd like your thoughts, Ms. McGillicuddy, on 9. It's one thing if the user of the account associated with Mr. Stargell posts a photo and then underneath it says, tough day in court today, whatever those are. And then other people's comments on there, you have a hearsay concern. Is it offered for the truth of the matter asserted? What's the foundation for it? Other than when we asked Instagram to scrape the account, this is what they sent back. I don't have concerns that that's what's in the account. I think there is a sufficient foundation for that, especially in this setting. But there's the hearsay piece where we don't know if at Roger Staubach said, hey, glad to hear you're doing okay, kid. Who's Roger Staubach and what's that about?
So my response would be just twofold.
Hmm?
One is, I would agree that the content of the comments themselves would be hearsay. My exceptions are twofold. One is, the primary purpose of tendering that exhibit in particular is to illustrate that at least 94 people commented. So that's to sort of go to the extent, the viewership of this series of posts.
Not what they said, but the fact that they received it and reacted to it.
Correct, to show sort of the extent of the harm of the post itself.
It wasn't just mom and dad saying, good to see your picture online.
Right. Second thing would be, I don't want to say effective on the listener because this is like a social media example, but the only, I don't plan to go through with the court all 94 of the comments, but the tone of the comments is very, I'm proud of you, congratulations. So the argument that I'm making here is that the tone of these posts was designed to appear victorious. And so it's a cumulative effect on the viewer, which is then what gets us to the community reaching out to the victim.
Sure.
So that's sort of, so I don't know if we could call that effect on the listener because it's a viewer rather than a listener, but
Well,
that's my response.
it also sounds like you aren't going to be insisting that I find that a third party comment is true. You're not offering for the truth of the matter. So it may be that person's not proud. It may be that person was ashamed, but the words were what they were. And your argument ultimately is going to be not whether that made Mr. Stargell feel good that he has a fan base, but the impact it would have on the victim and her family as they are observing this victory dance and this online victory party in a situation where no one was victorious.
Right.
I'm using the words I suspect you're going to use.
That's correct. Jeff.
Okay. All right. I'll admit Exhibit 9 provisionally. I need to sort of see it as it's going, and as I appreciate Mr. Steele's candor in his objections. Because this is a non-jury setting, I have an ability to say, I'm not gonna pay attention to that. And we don't have the same concern that jurors are gonna say, oh my gosh, I just saw this, and now I feel real strongly about something. So I think in the context of this proceeding, 9 is admissible, but it may be that you need to pull it back if you keep talking about, look, this person said X, and that person isn't Mr. Stargell, but
Right.
some effectively unknown commenter. And you may even be able to say, well, I know that's his cousin, but that person's not here.
I understand.
Okay.
So back to you, AC Spear. First of all, let's start with so we already talked about the post is, April 22nd, 2026 at 6:19 PM Eastern Standard Time. What was the caption that Mr. Stargell made to his post that contained those couple of pictures in it?
The caption was, it reads, "Thank you, Lord. What a privilege it is to endure a pain that can only make you stronger." And then it displayed a red heart emoji.
Okay.
And that's basically exhibit 2 or 3 already.
Yes, that's what's at the bottom, I'm delineating it, that's actually Mr. Stargell's words and not the comments that we're talking about next.
Right. Okay.
So next question is, they don't give you like a total of comments, you actually have to go through and count them yourself, right?
Yes.
Did you do that?
Yes,
How many are
94 comments.
there? Okay,
I want to pause things for just a moment. Mr. King, good morning. Do you need to speak with Ms. Smith?
Probably need to speak to my client, he's here.
He's here, he's up, so you can talk with Deputy Gordon. I don't know what our deputy staffing is, whether you can be in lockup while we're out here, but check with Deputy Gordon, and I was just connecting you and Ms. Smith, because we're gonna have a few minutes for you all to talk, both with your client and with Ms. Smith.
All right, thank you.
Sure. I'm sorry, Ms. McGillicuddy.
no, you're fine. Without getting into specifically each individual comment and repeating what was said, in reviewing them all cumulatively, what would you say is sort of the tone of the comments?
I apologize. And I heard what you just said, you can take it in, figure out, but that's speculation. You could read the comments to yourself, over objection.
Okay. Response?
Either I'm gonna read them individually, or I can ask him to just summarize without getting into the hearsay aspect. I still think I have the same response, it's the effect on the viewer, it's the effect, I'm not.
Right, I think the better way to do this would be to put a few up on the screen so that what the record is not is Investigator Spear's opinion, that, hey, I read these as X. Because in the end, you're going to be advocating for me to interpret or process them in a certain way. That would be your argument, but ultimately I'll decide harmless, not harmless. And it's really, with all due respect to the investigator, not his opinion, like, hey, I read these as being offensive or neutral or whatnot.
I understand, so Judge, I'm not on the Zoom, but would it be okay, since the exhibit's already tendered and the comments are already there, would it be okay then for me to just have him read a few? Or is that?
Either,
I'm gonna put
however,
them up, because I just don't have a way to do that conveniently.
however you want to do it.
Okay. Investigator Spear, you've reviewed these 94 comments,
Can I
right?
just say something, Your Honor?
Yes, sir.
And I apologize. I asked Mr. Stargell if he'd not be able to check something for me on his phone. I just want you to be aware of that.
Got it.
He's not. Anyone checking.
All right, I wasn't feeling rudeness. I also was looking over here, so I didn't even notice, but thank you for flagging that. Press on.
You reviewed these 94 comments, is that right?
Yes,
Okay, and in reviewing them, were there any that stood out to you in particular?
yes.
Okay, could you just
Mhm.
read them from the page itself, just so, and I don't know that we need to put the usernames on the record, but the content of the comment only.
Do you have a copy I can be looking at, or that's the copy? Okay, then they need to be right there unless you've memorized them.
Your Honor, we have a continuous objection to all this stuff.
You do. No, you have objected to foundation and relevance and hearsay, all preserved and ongoing in connection with probably not the return, but the kinds of things where we're getting into the nuts and bolts of what's said and the content. Yes, I'll make very clear on the record, it's a continuing objection. And I don't mean to speak for you, but there's the question of foundation, and thus perhaps authenticity, certainly hearsay. Were there other
Due process.
and due process? Okay.
And I might be able to do this easier as long as I'm not going to get another section for leading, because I have 8 notes on them. Is there a comment that says, "So proud of you, the truth will set you free always"?
Yes,
Is there a comment that says legendary?
yes,
Is there a comment that says the redemption arc is finna be Oscar-worthy movie, get your popcorn ready, love brother?
yes,
Is there a comment that says truth wins, proud is an understatement?
yes,
Is there a comment that says, hell yeah, truth always gonna win?
yes,
Is there a comment that says, let's go, we free?
yes,
Is there a comment that says, love you so much, fam, no weapon formed against you shall prosper, Isaiah 54:17?
yes,
Is there a comment that says, free that boy?
yes,
Are those just a small smack of the 94 total?
yes, they are.
Okay. I don't believe I have any further questions at this time of investigator or AC Spear.
All right. Do Mr. Rousey or Mr. Steele have questions? Just one of you have questions for Investigator Spear.
Yes, Your Honor.
You're up.
And if I may, at the conclusion, just confer.
Conferring is great, and I'm fine as to which one of you does it, but it wouldn't be, I'm gonna take half the questions and Mr. Steele takes the other half.
I just want to make sure we could confer for.
100%.
The client's inclusiveness here.
Good morning, investigators. Is it Spear?
Spear.
I've got just a few questions for you. You had indicated that you first became aware of these posts through Luke Hicks. Is that correct?
I first became aware through the post, through basically our division here, the Special Victims Division, with our victim witness advocate Carla Martinez, and also Deputy DA Kayla McGillicuddy.
All right. They informed you of what they perceived as a problem.
Yes.
And when you were tasked with following this up, did you go out, or how did you come into, I'm specifically trying to draw your attention to what you testified to about Luke Hicks.
Mm-hmm.
Tell me, just briefly, did he send you a snapshot or a screenshot of the evidence that we're talking about here today?
So once I began my investigation, of course, I speak with my staff, and then I was able to speak with Mr. Luke Hicks. He was able to send me 3 basically pictures, which are indicated in the record that I previously spoke about. He sent me those pictures, and he also advised how he was informed of the information.
That's the question I wanted to ask you about. What did he tell you?
He advised that that his family, his sister Claire Hicks, and that others, specifically his girlfriend, contacted him, basically saying that there was a social media post in reference to this case that was basically in direct violation of the judge's order in relation to this case.
Okay, and very specifically, did you inquire who told Luke about those posts?
Judge, I'm gonna object at this point. I think that's not it calls for hearsay, but also it's not relevant. Who told who about what? The pictures are what they are, and the family was contacted about them. I don't think it really matters who originally saw it, who told Luke about it, who asked Claire about it. The point is, they were made and they were repeatedly contacted.
Okay. tell me the relevance of this.
But Judge, I think it goes to the heart of this issue.
Okay, which is,
which
it didn't
is-
happen, it did happen.
Which is the court's direction, the order about probation is that Andrew Stargell shall have no direct or indirect contact with the alleged victim, Claire Hicks, or her family.
Right, and of course, the conversation was a little broader than that. Don't get on social media, things like that, and then here we are talking about social media. But we'll have that argument. Tell me why it's relevant. Who flagged this for Luke Hicks? Whether it was his sister or his mom or a friend or his girlfriend, how is that going to impact? To me, the longer the list, the worse it is for you and your client. I'm happy to say,
I guess this is where the fine point of the law comes down to bear on this is, and with due respect, I'm not arguing with the court, but the directions on the court order, no direct or indirect contact with the victim or the victim's family. Social media posts, we expect ours.
you're going to argue that later. Why does it matter who told Luke Hicks? Stargell's online talking about the case.
I want to find out through this witness if he's aware of any direct or indirect contact, how those social media posts arrived at the victim's family or the victim's screen. How did it pop up?
Okay.
If it was shared by a third party to them, that's all I'm trying to get at.
Okay. I see how that'll be relevant to the argument that you have already started and will be making soon.
Thank you, Judge.
Ms. McGillicuddy?
I think if he limits his question to, was a third party involved in sending it to Luke Hicks, that's fine with me. I still think if we're getting into names and people who may or may not have ancillarily been involved in the trail of people it took to get from Instagram to her or their family, I think now we're getting into improper content.
Okay. I don't know about improper, but to your point, in some respects, if it's a third party, it doesn't matter who that is.
That is correct, Your
It's
Honor.
just that it's not Claire Hicks. It's that Claire Hicks never, I'm making this up, but that she didn't see it directly, someone shared it with her. And then you're going to argue what you argue.
Correct.
And that's
Your Honor.
different from.
I'm not seeking those names. I'll keep it limited to the scope that the state just requested.
Then press on.
So with that in mind, Investigator Spears, my question is, do you know whether or not Claire Hicks or an immediate family member of Claire received those posts either directly on their screen or was it shared to them by a third party?
My understanding was that, I'll give a specific quote that Luke said. He said that everybody is contacting us, my family, in reference to these social media posts. He did state that his girlfriend actually sent him the post from the Max.Harrison 06. That was actually sent to him by his girlfriend, but he advised that his family had seen these posts from numerous individuals.
Okay, so they received them from third parties.
Yes.
All right, not directly from Andrew.
Not that I'm aware of.
Right. And you had indicated that this post was made based on your return on that search warrant, that it was posted on 4/22/2026 at 6:19 p.m., correct? Yeah. Do you have any other information as to how long that post was made available before or if it was taken down?
I do not, but based off of my investigation and the statement of Mr. Luke Hicks, the post was deleted rather quickly because when I went to and actually did my investigation and I looked at Instagram, I could not locate the post. And he had also stated that the post was taken down the same day that it was posted. And he also stated that his family said that.
All right. And did you have any conversations with the DA's office about any request that it had made to remove those posts?
Can you say that question again?
Have you had any conversations with the DA's office about the removal of this particular post?
Yes.
All right. What conversations were those?
We discussed that a post was made in violation of the judge's order and that it was taken down.
Okay. And what specifically were you aware of through the DA's office as to when that post, or was there that it was taken down?
That the post was made on 4/22 of this year, and that it was taken down most likely on the same day.
Do you have any understanding as to how soon after it was posted that it was taken down?
A few hours is the best estimate I could give.
That's your best estimate, right? Do you know if any requests were made by the DA's office to defense's counsel to have those posts removed?
I do believe that there was a conversation, but I won't be able to fully speak on that conversation.
All right. Judge, if I may confer with co-counsel and my client.
Yes, sir.
Investigator Spears, in your pursuit of this information and review of all of the search warrant return from Meta, you able to determine whether Luke Hicks's girlfriend was blocked on social media?
No, I was not.
Let him finish the question.
Yeah.
Blocked.
Well, on social media or this Instagram account?
Can you ask the question again?
Well, you received 1,200 some odd pages from Meta. Did that information let you know who may have been blocked on Andrew's account?
I'm not sure at this time.
Did you look?
Yes.
What did you find?
In reference to who was blocked,
Yes.
I can't speak to that at this time. I don't recall seeing any information about who was blocked.
Would it surprise you to learn that Kendall, is it Berg? Kendall Berry is blocked?
You're asking, would it surprise me?
Yes.
No, it wouldn't surprise me.
Do you know who Kendall Berry is?
Yes.
Who is
It's
Kendall
Luke
Berry?
Hicks' girlfriend.
Would it surprise you to learn that the post was taken down within an hour of it being posted?
No, it wouldn't surprise me.
Would it surprise you that Luke Hicks is blocked on Mr. Stargill's account?
No, it wouldn't surprise me.
Tell me what you understand blocked to mean, Investigator Spear. Would that mean that someone who's blocked, if you know, and if you don't know, tell me that.
That was going to be my question, Judge.
Okay, well, I beat you to it. If I am blocked on Mr. Stargill's account, does that mean that I simply can't comment, but I could still see it? Or I can't see anything? Or what does blocking mean to you?
Instagram has different settings, specifically for blocked. They're kind of different variations, and in some circumstances, the user that is blocked cannot see the person's page at all. In some circumstances, they just can't access that person's page. In some circumstances, they cannot actually comment or communicate with direct messages or posts with the other user.
Okay. And do you know, I understand you wouldn't be surprised if certain things happen, and if the defense wants to put that up in a minute, they can. But do you have any knowledge as to whether anyone connected with this case was blocked or not blocked, and the level at which they were blocked to Mr. Stargill's account?
No.
Okay.
And if any of us as users of Instagram or any other social media have an ability to block, we don't want to hear from so-and-so. Can you block that person so you don't see those posts or otherwise?
That is my understanding, but again, there are different levels to blocked and what actual content is actually blocked.
Okay. Thank you very much. That's all the questions I have, Judge.
Any redirect?
Yes, Judge. You were asked a couple of questions about this, on cross about whether or not a phone call took place. I called the defense counsel and told them that the post needed to be removed immediately. Isn't that right?
Yes.
Okay. Let's talk really briefly about this last point about blocking, privacy settings, things like that. When you have an Instagram profile, you can set your profile to private, correct?
Yes.
And that would mean someone could search for your account, right?
Yes.
So if you were to search for Andrew Stargill's profile, we could see his profile picture, just like a little bit of information at the top, and then it would say his profile's private.
Yes.
So it's not gonna display content.
Exactly.
And so if someone blocks a person, they kind of vanish a little bit altogether.
Yes.
Is that a fair way to describe it?
Yes.
Okay. And depending on whether or not your profile is private or blocked, changes the way those things appear when a person searches for you. Is that
Yes.
right?
Yes.
Okay. Even though your profile is private, right? When you post something, your friends see it. People who follow you, I'm saying friends, people who follow you on Instagram, right?
Yes.
Are they able to screenshot those posts and repost them as Max Harrison did in one of the exhibits we've already tendered?
Yes, they are.
Okay. And then all of Max Harrison's followers can see what's posted. And now we're talking about Max Harrison's privacy settings and not Mr. Stargill's. Is that a fair way to?
That is correct.
Okay. So Instagram and really all social media is not so much of a line as it is a weapon.
Exactly.
Okay, so once you've posted something, regardless of the efforts you've made to control the audience, you really can't. Is that a fair way to describe it?
Yes, it is.
Okay. And even in the short amount of time that the post had been live on Instagram, when I say live, not an Instagram live, but the post had actually been on Instagram, viewable, in just that short span of time, 94 people had commented.
Yes.
And that's not a tally of how many people saw it. Is that fair?
Yes, that's fair.
And does that encompass anybody who may have saw it on Max Harrison's?
No,
Okay.
no, it does not. No,
And do we know if it was shared by anybody else?
we don't.
Okay, so, and 94 is not viewer, it's only the people who took the time to write something.
Exactly.
Okay, no further questions.
Thank you, Investigator Spear. You can step down. Both sides, you have a right to continue to present witnesses. I want to make sure we aren't unnecessarily making a production out of this. And here's all I mean by that. Not that this isn't serious. It's very serious. It's problematic. What happened shouldn't have happened. We're going to work through the consequences. There's not a fundamental disagreement here that Mr. Stargill posted some things. He may have tried to cabinet. That never works online. It didn't work here. They ended up in the lap of Ms. Hicks and her family. And we need to work through, are there consequences of that? You can call 7 more witnesses. We can get someone from Meta. We can have Mr. Stargill say, I didn't mean for it to go somewhere else. And here's what I intended by that. In some ways, that doesn't matter. And we can get other witnesses. We can have Luke Hicks testify. Here's what I saw. Here's how I got it. The bottom line is things were posted, and we need to work through whether that was inconsistent with the condition of probation. And if I find that it was, what should the results be? We can have other witnesses, but I don't know that it's doing much more than getting both sides more frustrated with this process, that someone was charged, that someone was a victim. And that doesn't strike me as being particularly uplifting or bringing any sense of closure to either side, for us to have a whole bunch more witnesses going around this circle of what we all know happened. There were some things posted, either that was a good idea or a bad idea. Either it was consistent with the terms of probation or it wasn't. That's what we're here for. Having said that, you're free to continue to make your case. I've heard there could be 3 witnesses from the defense. No one is going to come in here to say, and be truthful under oath, he didn't post it. It didn't get to Claire Hicks. Both those things happen. And that's the nut of the issue. And that's what I think we need to have argument about. And I don't know that I want to spend all day, but I will, because it's your time and it's your case, both sides, hearing from witnesses who are, well, that's not exactly how Instagram works. And this is what this person thought. And I blocked this person. Blocking one person with an online post is like saying, well, the billboard was only in my neighborhood. It wasn't in this other neighborhood. But people will talk about it. People will take a picture of it. Once posted, forever online, forever and ever. And as prosecutors and defense attorneys, you know how that works, because someone gets a picture of someone else. Oh, I only send it to one person. It could go anywhere. This did go everywhere. And that's a problem. The question are, what are the consequences of that? And was it even inconsistent with the terms of probation? I'm done. I just want to let you know where I am in thinking about the issue that is created by the state's motion. And we'll continue on with the state's presentation, and I'll turn to the defense and give the defense a full opportunity to call all the witnesses they think are needed to further refine the issue. Ms. McGillicuddy.
So Judge, I sort of at this juncture have tendered all the exhibits and what I believe to be a complete record to establish that a violation occurred. The only other person I was going to call was Jay Hicks, and that's more goes to the impact on Claire. So that would be more of like to inform the court's opinion of how severe the violation itself.
And I don't ever want to preclude victim impact statement in the same way I would never preclude a defendant from allocuting to say, here's what I think you ought to do and what I was thinking, and I'm sorry, or whatever, I'm not sorry, whatever the words might be. I can't imagine the impact was anything other than hurtful, destructive, hard to believe that coming out of a case where someone who went through all that she did was in any way indicative of, we've got closure here and we can move on. So if you think that I ought to hear more, because someone could certainly be more eloquent and speak more to, well, this is Jay Hicks is what relation to
Claire's spot.
Okay, so this is my daughter, and let me tell you the effect it had on her. We can certainly do that if you think that that's necessary.
If I could just have 10 seconds, I may be able to shorten it up.
Sure, and talk, because it may be that if they could avoid having to talk about it, they'd prefer that. Now that they know, I understand fully how 30 minutes after leaving court, something like this is happening. And again, really what we're working through, and this is going to frustrate people here who are passionate on both sides, is, but then there's the technical question of, was what happened wrong from a probation sense? It may be wrong on 5 other dimensions, and there may be a lot of soul searching that needs to happen in the Stargell family. But if it's not a violation of probation, then I can tut-tut at people, but that's not my role. And we're done with the piece of, does it have an impact on probation?
No, I understand what you're saying. If I could have 10 seconds, I can.
Sure.
Judge, if we could even have a 5-minute break, maybe.
Well, let me see this. Ms. Smith or Ms. Williams, are either of you ready to go on one of the pleas? Because we could pause this proceeding, take a plea, and Ms. McGillicuddy could speak with the people she wants to. You all could speak with whom you want to speak. And then it could be that we pivot to where I know you want to get, which is the argument of, look, these were the conditions, it's a violation, it's not a violation, and if so, these ought to be the consequences. But I want to repeat, There may be witnesses who need to be heard from the professional perspective of both sides, and 100% okay, we'll do that.
Thank you, Judge. If we could have 10
Well,
minutes or so.
let me find out, because you'll get less time if there isn't a plea that's ready to go. Thank you.
Your Honor, I believe that, Mr. Cook and Mr. Pendleton, are you all ready?
We could do the Pendleton plea.
Yes.
Okay, all right, let's do that. So, Mr. Stargell, I'm gonna ask you to step back from that desk, be with family, lawyers, whomever. And we'll take the plea in the Pendleton case. We'll pause the proceedings in the Stargell case and re-engage after we take this plea.
Your Honor, we're stepping out.
Yes?
Thank you.
So if you are able to stand, Mr. Cook, if you'd be at the podium, and Mr. Pendleton, if you would be immediately to his side. Thanks. Let me know when you're ready.
Yes, Judge. And before we start, I know please, Your Honor, let me know where you want me to start, because I know we kind of went through some of this. I don't know if you want me to go through everything all over again, or just tell me what you.
We did a whole plea and then it was withdrawn,
Right. So we need to do it again, because that was a plea that didn't go through. So I'll open the record. This is 25 SC 002-761. It's State versus Pendleton. Mr. Pendleton is here in court with his lawyer, Mr. Cook. Ms. Williams is here for the state. I don't remember if it was final plea or the last trial calendar, but at a preceding court appearance, the state and the defense tendered, I think it was a negotiated plea.
it was.
It's one I didn't accept for reasons I made very clear on the record. Given the additional steps the state contended Mr. Pendleton took in connection with the online exchanges he had been having. And I tried to level set as to what I thought would be a reasonable sentence, given the facts as they were represented to me by the state. And Mr. Cook, you weren't pushing back on that's not what happened. It was you were advocating for a different sentence. Consistent with my guarantee to Mr. Pendleton, he was able to withdraw his plea at that time because the sentence that I said would be consistent with what I felt the evidence was and the gravity of the offense was greater than or more severe than what Mr. Cook had been asking for. We set the case on this trial calendar, which was called back in May. This Monday was the day we would have started trial. Mr. Cook explained it's not a trial, it's a plea. But Mr. Cook had a conflict and was needing to be in a different jurisdiction Monday, maybe Tuesday of this week. I think, Mr. Pendleton, you've been in town for a few days now.
Been here since Monday.
Okay, so you've been here for a while, but we are now in the position to do the plea again, and we do need to start from scratch for the record. And so some of this may seem a little repetitive, Mr. Pendleton, but
All good.
you'll recall the process. Ms. Williams will put you under oath, ask you questions about your rights and the case, et cetera. You need to answer those truthfully and completely. And you need to let me know if at any point you have questions or you need a moment to speak privately with Mr. Cook. You'll do that?
Thank you. Yeah, yes, Judge. Thank you.
Okay. When you are ready, Ms. Williams.
Thank you, Your Honor. Mr. Pendleton, could you please raise your right hand? Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes, ma'am.
Please state and spell for the record your full legal name.
Aaron Michael Pendleton, ARRON-MICHAEL, Pendleton, PENDLETON.
You can put your hand down. Thank you.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
25.
What is the highest level of education that you have completed?
Some college.
Okay. Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Mr. Cook, on behalf of your client, do you waive formal reading of the indictment?
Yes.
Mr. Pendleton, do you understand that you are charged with the following offenses as to indictment 25 SC 002761? You are charged with criminal attempt to commit child molestation, as well as use of a computer service to seduce, solicit, lure, or entice a child to commit an illegal act.
Yes, ma'am.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Cook, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with Mr. Cook?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Cook, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
Mr. Pendleton, have you been arrested on these charges?
Yes. Yes, ma'am.
Mr. Cook, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
No.
Mr. Pendleton, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
Do you understand, sir, that if you are pleading guilty to a crime against a minor, including kidnapping, false imprisonment, or conduct of a such sexual nature involving a minor, or if you are pleading guilty to a dangerous sexual offense as defined by law, you will be required to register as a sex offender?
Yes, ma'am.
Do you understand, Mr. Pendleton, that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, ma'am.
And Your Honor, and Mr. Pendleton, as to the actual joint recommendation that we would like to make, the state would, first of all, move to dismiss the use of computer service charge and proceed with the criminal attempt charge with a recommended sentence of 10 years to serve 1, the balance on probation with full sex offender registry as required, et cetera.
Okay, so the condition of probation would be one that would really be by operation of law, which is register. It'll be the special conditions of probation that flow to someone who is having to register.
That's correct. That's my
Okay.
understanding. Mr. Cook?
Yes.
Okay.
Mr. Pendleton, having heard the terms of the recommendation, do you wish to proceed with the plea?
Yes, ma'am.
Do you understand, sir, and hopefully you will never receive another conviction in your life, but should you ever receive another conviction, do you understand that this plea may be used to enhance or increase sentencing on any conviction that you receive in the future? And that applies in the state of Georgia, any other state, and any other jurisdiction.
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Sir, are you a U.S. citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
And Your Honor, if I may have a minute. Mr. Pendleton, will you be asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, please. Yes, ma'am.
Have you ever pled guilty or no contest to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has Mr. Cook explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge in the indictment?
Yes, ma'am.
Do you still wish to proceed with first offender treatment?
Yes, ma'am.
I'm now going to go over the individual rights that you were waiving. Do you understand, sir, that you have the right to plead not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty, this matter could proceed to trial?
Yes, ma'am.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury,
Yes, ma'am.
as well as the right to remain silent and not incriminate yourself,
Yes, ma'am.
as well as the right to confront witnesses against you,
Yes, ma'am.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes, ma'am.
Do you understand that you are also giving up the right to the presumption of innocence,
Yes, ma'am.
as well as the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
as well as the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes, ma'am.
And finally, you are also giving up the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 25SC002761, how do you plead to the charge of criminal attempt to commit child molestation?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in the official code of Georgia, annotated section 5-6-35. Do you understand that, sir?
Yes, ma'am.
Do you understand that you have from today, Judge McBurney is going to go over with you the ins and outs of your ability to withdraw your guilty plea. Do you understand that?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness or constitutionality of this guilty plea?
Yes, ma'am.
Do you understand that the appeals and documents that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
And Your Honor, as to Mr. Pendleton's criminal history, my understanding is that other than this current case, Mr. Pendleton has no other cycles.
All right, we do have, since we're on that topic, Officer Bostic from pretrial. Good morning.
Good morning, Judge.
Do you
She's
have
correct, no prior arrest.
Got it. Okay, done. Thank you.
And I apologize, Your Honor, my technology is really strange right now. Your Honor, as to the facts of the case, had this matter proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on December 10th, 2023, Mr. Pendleton, who was 22 at the time, and undercover members of the Alpharetta Police Department engaged in discussions on FetLife or a similar site. Early in the exchange, the undercover officer gives to Mr. Pendleton a cell phone number for communication via text messaging, and the undercover officer is posing as a mom attempting to get her 12-year-old daughter, quote, experience with a man. Defendant receives a picture of the mom and the daughter showing two females who are both involved in the undercover sting, with one the approximate size of a 12-year-old as compared to the taller female who was posing as the mom. There's a conversation that ensues between the undercover officer posing as the mom, and she continues to discuss with Mr. Pendleton what she would like to have happen in terms of a sexual experience for her 12-year-old daughter. She also eventually gives to Mr. Pendleton the address of the pool house of the community where they supposedly lived. And mom said, the undercover officer posing as the mom then says that she will meet Mr. Pendleton at the pool house and then walk to their home. Mr. Pendleton was arrested at the pool house, and he then did speak with investigators after being Mirandized. He did state during that interview that he never intended to have sex with a minor, but that he intended to try to talk the mom into having sex with him. And that is the basis of the indictment and the basis for the plea.
All right, appreciate that. Question for you, but also Mr. Cook. I think you mentioned something about first offender for which Mr. Pendleton would otherwise qualify, but I was doing a little reading while you were gathering some of your information. I don't know that he's eligible, except that this is an attempt. That's the one wrinkle here that I couldn't find. If this were child molestation, that is defined as a sex offense under 1710 6.2, and those sex offenses, as defined by 1710 6.2, are excluded under 42-8-60 from first offender eligibility. So did you talk about this with Mr. Cook, and does the state have a position on eligibility? Not do you think it's a good idea, but is he even eligible?
Your Honor, I did speak with Mr. Cook about this. I believe that we are on two different sides of the issue, and that I believe even at the last plea hearing that we were going to place it in the court's hands, there was some case law indicating both.
Sounds like the Court of Appeals.
Yeah, it has not really been resolved yet.
Okay, all right, and I'll hear from you at the appropriate time on that. I just wanted to, if the state said, no, look at case State versus Smith, then we're done. But it sounds like there are at least two cases, so. All right, I've already heard from pretrial services, so Mr. Cook, I will turn to you.
Thank you, Judge. Your Honor, Mr. Pendleton was before this court in early March, tendering a guilty plea at that time. As the court stated on the record earlier, the court did not accept the negotiated plea of 5 years probation with that the state and defense had negotiated. That was primarily negotiated because of Mr. Pendleton's, at the time of this incident, his young age. He was a 22-year-old Morehouse University student with no criminal history, no issues like this in his entire life. And the court indicated it was concerned about the subsequent steps, of course, in the allegations that he took. The issue, because the facts as made by the state, and we don't contest that Mr. Pendleton was arrested at the pool house and that he made statements to law enforcement acknowledging the things that were written in the text messages. The point I still find to be an important point with regard to what Mr. Pendleton truly believed as opposed to what he got himself into was he was initially talking to an adult person, representing to be an adult person, responding to an advertisement for an adult person. And it was police action. It was a bait and switch. It may have been a good bait and switch. It may have been effective of what they were trying to do, but it was a bait and switch looking for an individual who they might be susceptible to this type of allegation. But there's nothing about advertising a sexual experience with a minor in the advertisement. It only came about after he started just made communication with an adult woman. To me, other people might disagree, but I still believe that is a critical point of this man was not out looking. This was not the purpose of this. This was an adult website, and I understand that the law allows the police to generate this type of investigation. But they found a crime that was not going to be taking place, that there was no evidence was going to take place but for their actions at the time. There just isn't any other evidence of any prior attempts or subsequent attempts or attempts that day for Mr. Pendleton looking to have a sexual interaction with a minor. I want to bring that to the court's attention. He was a nursing student at Morehouse in his last year, left school because of this, stayed in jail for a month. Never been in any situation like this in his life, was in a relationship with a woman who was 2 times his age at the time. It was actually, in my discussions with them, they were on the website was FetLife. They had a open relationship, a sort of fetish-based relationship. And he tells the police officers that he's since relocated to Las Vegas, Nevada to live with his mother. He has been working as a full-time personal trainer. He and has basically had to give up his job to come back here and resolve this case. I mean, my concern, I just want to put on the record, is my only concern is the need for society to say that what you did was unacceptable. That's true. And to be guided as well by not further marginalizing people who were otherwise on a good path. He was on a good path towards being a regular, just normal citizen, and we've turned over a psychosexual evaluation to the state, which provided no other indications of behavior and history that would put him in anything but a low to moderate risk. So that lowest sections, what that tells us is that Mr. Pendleton we don't want Mr. Pendleton thrown away. That's really our point. And we understand the court's position, and that's why we have tendered this plea to the pound of flesh, to Mr. Pendleton, to recognize that not only is this just not acceptable and he has to abide by probation conditions which are onerous and intended to be, protective, but also a bit punitive out there, that there's a punitive cost up front. And so he has flown from Las Vegas to resolve this case and ready to turn himself in immediately upon the court sentence. Judge, we do ask the court to use the carrot and stick method of first offender. We do believe it is, I've done the research I found that there is no case law that says it is not eligible. And the crime, the statute which he's pleading guilty to is criminal attempt, not child molestation. It does not fit under an exclusion under the first offender statute. what's interesting is that they had every ability to do that because they did it with the legislature did it with the sexual offenses, in that this is not a per se sexual offense, but it fits under the subsection of other offenses relating to inappropriate sexual contact with a minor, and that's why it's still covered under the sex offender registry, but it's not covered under the first offender. Given his young age, given the fact that he's going to do a year in jail, or what the court does, that's what we're asking the court to do, that court give him something to redeem himself, and not so that he is languishing forever. And if they decide that he, should be on for a long time, you can be revoked. I mean, that he's more under the court's thumb. I don't think it's just a setting it aside as not serious. So I think there is a carrot and stick method that gives the court more action over Mr. Pendleton. And so, and one of the questions is going to be, where is he going to go when he gets out? Unfortunately, his mother, but let everyone know now, his mother probably lives in a location where he may not be able to return to in Las Vegas. And his father lives in Kentucky. He's a retired DOC in Kentucky. He's a prison guard, right? Yeah, prison guard in Kentucky, who has appeared with him in cases. That's a possibility, but he's got to have some time to get that figured out. Judge, for all those reasons, we would ask the court to accept the plea that we have negotiated. As I've said before, it's a hard one for me, but I understand that it is what it is. So that's what we're asking the court to do.
Got it. Thank you. Mr. Pendleton, is there anything you want to add? You don't have to say anything at all, but you've got a right to be heard if there's something you think Mr. Cook didn't cover that I ought to hear.
I'm just trying to get my life back on track. It's been almost 3 years since this happened. I'm just trying to go ahead and get things back on track. I've started my amateur bodybuilding career that I have to go ahead and put on hold. I've gone ahead and been personal training for the last couple of years. I just want to go ahead and get this done, get this over with, so I can go ahead and continue on. I do know that there's going to be limitations when I do go ahead and get out. I'm ready to go ahead and proceed forward through that just so I can go ahead and move on with my life. I made a mistake. I know it was a deep mistake, and I said things that I probably shouldn't have gone ahead and be saying, but I'm just trying to go ahead and move on.
Okay. Well, I appreciate your thoughtfulness on that. I find there's a factual basis for your plea, and that your plea is knowing, meaning you've understood what we've been talking about.
Yes,
I know
sir.
you've consulted carefully with Mr. Cook and family. It's also voluntary, meaning no one's forcing you to enter this plea, but you've
Yes, sir.
decided it's in your interest to do so. Mr. Cook, can someone in my office sign the indictment on your behalf?
Yes.
Ms. Williams?
Yes, Judge.
And Mr. Pendleton, can we sign your name to the indictment
Yes, sir.
indicating your plea just to count two? Count one is being dismissed.
Yes, sir.
Okay. So a couple thoughts I want to share, and I'm probably repeating some of what I said last time when the plea didn't go through. It's not just what you said. Mr. Cook is correct that speech is protected, and you could be online all day long saying,
It was just something. Go ahead.
I want your 12-year-old daughter. And that might creep a lot of people out, but if it's just you posting that and you stay in your household and you're with a woman twice your age, or more importantly, you're with an adult and not a 12-year-old, then people who might be exposed to that speech just might think that's not my space. It was the set of concrete steps you took. And I didn't mishear, Mr. Cook. Your claim is I was there to try to convince mom to be with me, and kid could watch, who knows, but I wasn't there to be with the kid. I, in a previous incarnation, had defendants say, I was there to liberate the kid. I was going to show up and take pictures and get mom to say into my microphone, yes, I'm going to make my daughter available. Supposedly noble approaches. And yours wasn't ignoble if it was to be with a consenting adult, but there's always a story other than I was there for the 12-year-old. I'll never know, but the risk that posed, the extra steps that you took, make me believe quite firmly that there need to be consequences more, and they haven't been minor in your life. They upended your life. You had to quit school, quit a promising career. You've pivoted. That's promising, I think. And hearing what you've said about how you're going to pick up and keep moving forward, those are all good signs. But it is important that you also carry with you, which I know you will, the year-long memory of it. You just can't act in that space. You can talk in that space, but the moment you start taking steps and you show up at that pool house, I think reasonable minds can disagree, but very reasonable minds could say that's someone who needs to be incapacitated because he just got in his car, drove all the way to the pool house, got out of his car, wandered up to the pool house, having communicated in no uncertain terms, I'm ready for your 12-year-old daughter. May not have been your intent, but we don't have an ability to strap you up to a machine to figure out, oh, he really was just interested in the mom, or he was interested in liberating the child. We have to go on what your actions, not just your words, indicate in terms of a risk. And of course, because Mr. Cook is thorough, he had you evaluated, and you fall into that category of low to moderate risk, not no risk at all. And that's a good sign too. And that's why I think this is a reasonable outcome. And I'm not blind to the fact that we've gone 2.5 years and you've been in no trouble at all. Also a good sign. I've had cases where in that intervening period, lo and behold, look at the guy's phone and he's collected child pornography. Only an indicator that the police got the right guy. And that's not you, which is good. I will accept the negotiated plea and sentence you on count 2 to 10 years to serve 1 year with a balance on probation. You'll get credit for the time you've already served. You will be required to register as a sex offender, at least in Georgia. I don't know how that works in other states. If you seek to relocate to Kentucky or Nevada, I suspect you'll need to register there as well. That puts constraints on where you can live, the type of work you can do, et cetera. There is in some states an end to those requirements to register, but they vary by state, and you'll need to navigate that depending on where you land. But you understand that registering, at least as so long as you stay in Georgia, is a requirement of your sentence.
Yes, sir.
You'll also be subject, again, at least in Georgia, to a series of special sex offender conditions of probation that limit, consistent with the registry requirements, what you can do professionally, things like that, and where you can live. I don't know about first offender. I'm going to ask Mr. Cook to email to me and obviously copying Ms. Williams on whatever, if he's bumped into case law. And it may be his position is simply there is no case law. I'm going to poke around a little bit in the case law. I don't want to impose an illegal sentence. I need to comply with the law. Conceptually, first offender can make some sense for you. You'll be bearing a heavy burden by having to register. And if there is a way for you to get some closure that you would earn by 8-9 years on probation of being a model probationer, then let's keep a future for you. I just don't know if it is legal for me to do that. And it's right up on the edge, and not in the sense that illegal, we all go to jail, but it just would, is it a legally proper sentence or not? On many indices, you qualify as a first offender. Clearly, on the criminal history side, I think clearly how you have conducted yourself since this situation happened. But there is also the black letter statute that says if your crime of conviction is child molestation, you are not eligible for first offender status. And as Mr. Cook pointed out, it's not your crime of conviction, it's criminal attempt, but it's criminal attempt to, and then fill in the blank, it's one of the prohibited offenses. So I'm surprised that there's no case law. But that's not what you all said. You said that the case law may be conflicting. We'll see. We'll see what's out there. But I'm going to go ahead and sentence you now, not as a first offender. That's the default because I believe that's what the law says. I will modify that sentence to first offender if I'm convinced that I am not violating those statutes by sentencing you as a first offender. I don't want to delay this moving forward. You're going to go into custody. You're going to start earning credit on the time that you will be serving. And I will amend the sentence. And we don't need to have a hearing. It'll just be some emails back and forth about whether I conclude that legally I can amend it to make you a first offender. Mr. Cook, anything that you want to add in connection with your representation of Mr. Pendleton?
No, Judge.
Okay. If there is case law, and I thought I heard you say maybe there is, please send it to me and Ms. Williams.
Yes.
And Ms. Williams, anything else from the state?
No, Your Honor, nothing further from the state.
All right. Thank you. Thank you, Judge. Ms. Weaver, would you like a quick break before we get back on the record? Yes, of course.
Excuse, Judge?
Yes, sir. Thank you, Mr. Cook.
I will be done.
Mr. Brill, do you want to chat with me, and do you need a prosecutor around while you do that, while the court reporter is taking a break?
Judge, I really just want to know if you had part of the plea this afternoon is going to be reduced to a misdemeanor. I just want to know if the court had, and this is going to be something that's going to be in the court's discretion, so obviously we'll get there when we get there, but if you had a order to seal the case, or if you want me to provide a proposed order, I know that sometimes judges have one.
The latter. Nope, I'll get it from you. You will submit it in Word format with a copy to, is this a case with Ms. Smith or some other? Yeah, so you just say, Judge, this is the order we think you should sign sealing the case. You copy Ms. Smith. Never had an objection from her to sealing things.
That was why I don't really, we'd already talked about it. It's obviously in the discretion of the court. We'll get there.
Right.
Sometimes I know that some judges have orders that they already had, but
I'm not one of those. All right. We'll get back on the record with the Stargell matter once Ms. Weaver is ready to go. All right, let's get back on the record in the Stargell matter. We had heard from investigator Spear, and then the lawyers and I talked a little bit about where we were going to go next. Ms. McGillicuddy asked for a brief break. The defense asked for a slightly longer break. You got both. I took a plea in another case, and Ms. McGillicuddy, I'm going to turn back to you because you had not told me you had concluded your evidentiary presentation.
So Judge, after speaking with Jay Hicks and the family outside, I think we're gonna end it here and for purposes of the probation revocation hearing, I think the rest of the argument I can make sufficiently without additional testimony.
Got it. Thank you. Mr. Rousey, plan for Mr. Stargell.
Judge, we too have had conversations with Mr. Stargell and his family and agree with the state that I think the court has an appreciation for where the arguments are headed. We do have a computer, Facebook, social media expert available if the court has any questions or doubts the veracity of our argument. But given the statements from the court earlier, I think we are comfortable proceeding forward with just essentially arguments.
Okay, well, why don't we do that? And if you start to get technical in a way that I don't understand, I'll let you know. And it may be that that person can chime in just so that we're getting it right. What I don't want to do is misapprehend the situation and assume X must have happened this way because I'll repeat, I am not an Instagrammer. And so my kid is, and I can check with him, but that would not be.
We wouldn't mind if you did.
But that wouldn't be here in court with you having an opportunity to chime in. So we won't do that. He'll hear about it tonight. Don't you ever post something like that? But
Judge, we do believe that neither the state or the defense are arguing factual issues.
Right. It's not that it didn't happen. It's what did happen, what were the parameters of what happened, and I think most importantly, are there consequences that flow from what happened consistent with the conditions of probation?
Yes, sir.
Okay. Then with that, and you're right to, we don't really call it reopen the evidence, but to get someone to chime in to make clear how certain technical processes work. Why don't we pivot to argument? Before we do that, I will, over objection from the defense, I have provisionally admitted states 1, 2, and 3, which are already part of the record writ large, not of this hearing, because they were exhibits to the state's emergency motion, but I will admit those. So all of the state's exhibits are admitted. The defense objections are preserved. Relevance, hearsay, due process. There may have been others. I'm not excluding any of those. The record was made. Ms. McGillicuddy, when you're ready.
Judge, if I could, I believe I have the last word. Since it's my motion, I would just waive anything now and just.
Okay, that's fine. So Mr. Rousey, Mr. Steele, whichever one of you wants to share with me what you think ought to happen here, please.
At least for me.
Pardon?
Are they for me?
Those are from you.
Yes.
Judge, if I may approach, I have some
Copies of case law that I believe could be helpful to the court in understanding and appreciating the argument that the defense is going to make, if I may approach.
Sure.
Thank you.
Your Honor, I think the court has astutely zeroed in on what the defense's argument is in this case about the alleged violation of the no contact, direct or indirect, by Mr. Stargell to his alleged victim, Claire Hicks, or her family. The cases that I just cited or provided the court are Marks v. the State, a 306 Georgia Appeal 824 2010 decision, a Collins v. Bazan, a 256 Georgia Appeal 164 2002 decision, and then the Chan v. Ellis decision, 296 Georgia 838, a 2015 decision. And these are representative decisions rendered by Georgia appellate courts, and particularly the 2015 decision that basically addressed contact. And admittedly, I don't think any of them are probation violation. Maybe one of them was.
One of them is.
Yeah, one of them is.
The Marks versus State starts with a court may not revoke unless the defendant admits or it's proven by a preponderance.
Correct, Your Honor. But and I believe in that one, the defendant was sentenced to no contact with
his ex-wife,
with the victim ex-wife, and he was posting on websites, so on and so forth. And some of the language in the court's decision rendered that contact is readily understood by people of ordinary intelligence as meaning to get in touch with, communicate with, while a probationary condition that forbids a defendant from contacting the victim may also be interpreted as prescribing indirect contact. Such contacts must still, for the purpose of getting in touch with or communicating with the victim. And the court concluded that the general postings were not intentional or efforts to contact the victim. The Supreme Court decision of 2015, I think, drives home our argument and point that an individual with a temporary restraining order that was posting on websites, even if they were untrue or so on and so forth, they were posts about the individual and not directed to the individual. In those cases, there was no evidence that the defendant or the appellant did anything to cause these posts to be delivered to her or otherwise brought to her attention, notwithstanding that he may have reasonably anticipated that she might come across the post. So that's just, again, for the court's reference, our argument in this case. We're not denying that there were posts made that have been admitted into evidence that Mr. Stargell certainly wishes he could take back. We understand and appreciate now how hurtful they were, but Mr. Stargell did not have any intent for those posts to reach or communicate directly or indirectly with Claire Hicks or her family. Admittedly, the evidence shows those posts did get back to them, and that was my question of the investigator Spears. Is there any evidence that it was posted to them? And I believe the evidence, well, I'll let the court determine that. And I know where the court stands on it, that this was sort of this is a billboard out there and they're going to see it, or what neighborhood it's going to come in, so on and so forth. But the case law seems to support our position that such a post there has to be an intent for him to have communicated this to the victim's family. We could put Andrew on the stand. We could do this, that, or the other. I can assure you, and he will answer the court's questions in any type of allocution or otherwise, but he had no intent for this to agitate or disturb the victim's family. Acknowledging the court's instructions at sentencing about social media, and that if anything on social media about this case got back to them, he would have to answer to it. And this is where we are today, answering to it. The posts themselves, at least as far as Andrew's post goes, does not mention the victim, does not elaborate on anything other than express his true, sincere elation to be finally done with what has been a tremendous emotional issue for all families involved. At the sentencing hearing, you heard what the state's evidence would be, what the defense was, the reasons why Andrew decided to close this case out and forego his right to a jury trial. The incident has caused him to miss out on many, many things that he otherwise was on track to enjoy. I will tell you that I've had conversations with Andrew about why did you post this?
And he said?
And he said that it was in an effort to let the community know, particularly coaches, recruitments, all those that followed him, know that he's done with this, that it's over. When he was in high school, and this, I spoke with the coach, we couldn't get him here today. He had to work short notice or otherwise, but Coach Vince Vance, who is a former University of Georgia player, a Chicago Bears player. He coaches kids, and what he does is helps guide them through the process of, and I was surprised to hear this, Judge, even in high school, the kids are posting and following and doing all the internet stuff to let people know, while they can and can't say certain things, they subliminally say, I want to thank the Roswell High School for my years here. They'll let them know he's moving to another high school. Or in the portal that's going on now, to let everybody know, hey, as soon as the contact provisions come up, you can contact me. While that may have been his short-sighted explanation for the post, I believe, and this is just my personal opinion, that it was relief that this was all over. For nearly 2 years, he has been absolutely silent on social media. He has been good on bond conditions, curfew, drug and alcohol test, all that stuff. He's a good kid. Admittedly, there's allegations that this is a serious, but he's a knuckleheaded 21-year-old, 22-year-old kid that's grown up in a culture of Facebook and posting, doing all that stuff. We got to confer with experts to understand what blocking means. So when you heard my questions and what our expert, Chase Ritchie, if the court wants to ask any questions of him, we had him delve into Andrew's account and his mother's account on social media, explain to us what the meaning of blocked is, or private, public, so on and so forth. I get it from the court's perspective. I share your experience with Instagram or social media and understanding generally that that stuff goes out and it's out there forever. But I think the court's decisions are trying to catch up with what society has become with all this communication and whether or not it's appropriate, prohibited, freedom of speech, communication or otherwise. But a young kid like Andrew, that's the world he grew up in. And he thinks it's over. I don't believe, and certainly don't want to take issue with the court, I don't believe there was a restriction on his use of the internet. That's a vague and general statement. But I think for a kid like Andrew, he's not restricted from using the internet. That's a means of communication. He also is familiar with, I blocked so-and-so, or they've blocked me. And I asked our expert, I said, well, did Andrew block the Hicks family? He says, no. I said, well, how did they block him? He says, yes, they blocked him. Therefore, he can't find them to block them. So he's aware of all of this, rightfully or wrongly believes, well, I'm not communicating directly or indirectly to them. And there was nothing, and this is probably a matter of opinion or subjective, nothing offensive about what he said or posted with those photographs. We understand that this has been a long process for everybody, and that the victim and her family were not pleased or happy about the resolution or otherwise, and that they don't want to hear from Andrew or his opinions or his friends' opinions.
And in particular, they don't want him to post his opinions online, blocked or not blocked.
I understand, Your Honor, and that's where we're at. Any questions the court has of it, but I think the court understands where we're coming from. I know that Andrew took that post down immediately. I left here. I got home, relieved that the case was over, and I get a call from Miss McGillicuddy. And I wasn't sure if I should discuss a whole much because I had started enjoying a cocktail to relax. But she said, look, tell him to take it down. We don't want to have to do this. I said, absolutely not. Called the family. They took down the post. I don't even know which post it was. And in fairness, Ms. McGillicuddy, I don't think she knew what the post was. Whether it was Christie's post, which Andrew didn't have arguably anything to do with, or if it was his own post. But we believed that cured the problem, and I don't believe Mr. Scargill has come anywhere close to the line on anything like this again. That's about it, Judge.
Got it. Thank you. Ms. McGillicuddy.
Judge, do you mind if I stand at the table?
I don't.
Is that okay?
It is.
Okay.
It's really whether Ms. Weaver can hear you. If she can hear you, you could stand in the back of the
I
room.
think I'm loud enough. Judge, I'm going to start with the case law that was just provided to me. I had a chance to briefly look over it, and I'm going to reference the Collins versus Bazan case first, as well as the Chan versus Ellis case. Both of these cases, I'm going to distinguish what we have before us here from both of these cases and ask that you not consider the reasoning of the court in deciding this matter, because both of these pertain directly to contact as it's defined in a stalking statute, which is a totally separate offense. And I'm actually going to point to the very tail end of the Collins versus Bazan opinion, where it's talking about in order to navigate a statute around the First Amendment, you're having to delineate harassing or intimidating contact and specifically exempt that from protection under the First Amendment. And that's how you get around a First Amendment challenge to either, for both of those cases, to that specific crime. So Mr. Stargell has not at this time been charged with an additional crime of stalking. So we're dealing with a whole separate framework for assessing whether this is a violation. So I'm going to set those over here. I am going to pull up this Marks versus the state case because I do think that there's some pieces to that that are instructive. I will highlight that in this case, the posts that were made by Marks, I guess, about his ex-wife were made under third-party accounts that did not reflect his name. And her statements were that she knew it was him because there's no other way that somebody could have known to post those things if not for that. So there were some other issues, I think, with the proof requisite in that case. But what I would like to point out to the court is that right at the first page of the opinion, we've held that the service of probation is a privilege and that while a person is on probation, quote, his private life and behavior may be regulated by the state to an extent that would be completely untenable under ordinary circumstances. So that's taking it outside of that assessment of whether or not it violates his First Amendment right.
Yeah, I circled that in red. I was reading that.
Oh, okay. Well, there you go. Nevertheless, the trial court has the authority to revoke a probationary sentence only when the defendant has violated the rules and regulations prescribed by the court. And then later it says certain, definite, and free from ambiguity, and the benefit of any doubt should be given to the accused. So really we're asking, were the instructions given to Mr. Stargell on April 22nd, 2026 sufficiently clear and unambiguous to inform him that that was going to be a violation of a special condition of his probation? Just turning back to my actual argument, Judge, I'm not going to belabor these points because I know the court's aware, but OCGA 42834.1 sets out the parameters within which the court is deciding whether or not to revoke probation based on whether it's a general condition or a specific condition. This would be a special condition of his probation, which means based on the maximum amount of time allowable would be the balance of the 5 years that he has in custody would be up to the court. And it's obviously a preponderance of the evidence standard. What I am going to do, and I'm not going to quote you back to you, but
I'm going to quote myself when I make my findings. So
Okay.
if you were going to go to the transcript from the plea colloquy,
Yes.
I will get that on the record.
Okay, so I'll skip that as well. I do just want to point out that nothing about what Your Honor said that day was not clear and unambiguous. I know that because as I stand in my place as an officer of the court, when I exited the courtroom with the Hicks family, Claire and her parents, the first question that they asked me was, what should we say if someone asks us what happened in court today? And I told them what my answer would be and said, you know, you can say the truth. He entered a plea to felony sexual battery under first offender, and he's on probation. I mean, that's the answer. That's the true answer. They were very concerned with whether or not something they might say might violate what Your Honor said. And I had to explain to them, they're not under sentence. Mr. Stargell is, but they showed such a concern for whether or not what they were going to say was going to violate what you said. I also can state my place and say that Claire was very clear with her parents that she didn't want them to call anyone. She didn't want them to post anything. She just wanted it to be over. So I got home, received calls, much like defense counsel just mentioned. And at that point, I hadn't seen any of the posts to even know who had made the post. I want to be clear. Mr. Stargell didn't delete these posts on his own because as he's getting 94 comments on something, realizes, maybe this was the posting regret. Maybe I've done something I shouldn't have done. Let me back this up. He deleted it because I called both of his attorneys 5 and 6 times to try to stem the bleeding as quickly as possible. Because what I have on my hands now is a set of parents who thought they were walking out of this court, having heard the judge's instructions to have some peace and some calm and begin to heal as a family. I spoke to Claire that night myself. I listened to her choke back sobs. I listened to her tell me that she wished this were over. She's not here today because she doesn't care. She's not here today because I spoke to her parents yesterday and we decided together that to put her through this unnecessarily again would be even more trauma than what she's already piecing through as it is. You can see from the amount of people in this courtroom, from Mr. Stargell, the number of comments in just that short amount of time. Roswell is a small community. It's about a 500 graduating class. So 94 comments in that short amount of time is a big deal for their community. That's a lot of people for it to keep drumming up this gossip, this nonsense, and this victim bullying, because that's what it's turned into. That's the effect that Claire's dealing with. Falsely accused creates a real problem. These posts are not innocent. These posts are not a knucklehead. These posts are not, a way for him to communicate with coaches that he's done with this case. You pick up the phone, you send an email. You don't post on social media with your defense attorney making a peace sign, all smiles ear to ear with the Fulton County courthouse signs in the background. This was a deliberate attempt to portray a victory, to portray triumph over evil. And
The falsely accused part, where is, I don't attribute that to Mr. Stargell, having said that. Mom said a whole lot of stuff that did not help her son. We should be clear.
So mom says these things in her post.
Oh, right, a false accusation, line 2 of her post.
Correct.
Okay.
And on the bottom of her post, you can see that little sliver of images because it is a screenshot. But those 2 pictures at the bottom of her post are the pictures that he posted. So it's not as though this isn't there, they had just returned back home from court. This is a pretty coordinated effort for the community to perceive their family and her son and Mr. Stargell himself as having had some victory over the false accusations made against him. That there's no other way to interpret this but that. And that is the effect it had. You can infer intent from the natural necessary consequences of your actions, but that is the effect it had. The Hicks are being inundated with contact about, well, how did the case get dismissed? I mean, that was the purported intent, and that is exactly what happened. The community had this impression that somehow Mr. Stargell walked away free, and that's not what happened in court that day. We heard defense counsel talk about relief, giving him some relief or some benefit of the doubt because he's a knucklehead. I stood here, I heard the court's words. You could be a knucklehead and still hear what you had to say, the family as well, and still understand what the plain English of your words was to him and to his family. The only other thing I'm going to say, Judge, is, I've been doing this 10 years. Judges say a lot of things when they pronounce sentence. And only the court can decide the weight that litigants, defendants, the state, any counsel that appears before it has. Only the court determines that. Because from where I stand, this was a tremendous smack in the face. Not just to Miss Hicks, Claire Hicks, not just to her family, but to the state, to the court, to the benefit of what he was given as far as going so far to avoid having to put Claire through this. Not because Mr. Stargell's innocent, not with his DNA in her vagina and rectum. No, because there are other considerations to make about what that puts the victim through as far as trauma, as far as accusations about her character. There are a lot of reasons that we would elect to go this route as opposed to trial. And this is a smack in the face. And it didn't give her any of the relief, any of the closure that she was supposed to have been afforded that day. The state's asking, Judge, that you revoke his first offender so that he will be adjudicated as a felon for the crime that he entered a plea to. And in revoking that first offender, he needs to be resentenced. And the state would ask the court to resentence him to 5 years, to serve 1 in custody to begin immediately. And after that 1 is served, he can be returned to serve the balance of his sentence on probation. To reiterate the no contact provision. And I believe that's more than fair, given the chance he was given not a month ago. Thank you, Judge.
Thank you. Mr. Rousey, I can't remember if you addressed this, and if you didn't, I'm asking now. I'm not asking you to come up with rebuttal. But I forgot to confirm if Mr. Stargell wanted to say anything, because of course he can if he wants to. He may not want to. You are his spokesperson, as is Mr. Steele, and you all have spoken some. But I wouldn't want this to reach a conclusion, and you had expected and intended for Mr. Stargell to be able to say something. 100% up to you and your client. It just dawned on me that I couldn't remember if you said, you certainly relayed to me his thought process, the family's thought process, et cetera, all of which I've absorbed. But I don't want to shift to what I need to say until we cover that.
I appreciate that, Judge, and I think I did make some reference to possible allocution or a statement to the court. If I could just confer.
Please.
2 minutes right here at the table.
Great.
Judge, I believe Mr. Stargell would like to address the court.
Mr. Stargell, good morning.
Morning. First off, I would like to say I'm sorry for the post. I never meant for any of this to happen, nor for it to get back to the family. It was never supposed to be a victory post. It was a relief post. I was happy that after 2 years of, getting labeled as something that's not great, it finally was over and I was relieved. I never meant for it to get back to the family, and that's why I had them blocked on my social medias, and that's why they had me blocked. But I'm just sorry. I don't want to undermine any of the pain they went through. I understand I'm the one under probation, and I apologize if I went against any of the court's orders.
Okay. Tell me what you are doing this summer.
This summer, I'm a student at Georgia Military College, and
You're doing a summer term there?
Yes, sir.
Okay. And do you reside there or do you commute up there for class?
I commute.
Okay. From Fulton County?
Yes, sir.
Okay. And what's your course load? Not meaning what classes are you taking, but how many?
2.
Okay. So that's how many days a week are you heading up there?
I'm there. I live there. I'm there 5 days a week.
I'm confused because I thought you said you commute.
I'm sorry. I must have got it mixed up. I live there, sir.
You live on campus?
Yes, sir.
Okay. All right. But classes aren't 5 days a week.
They are, sir.
They are 5 days a week. Okay. All right. Thank you. Mr. Rousey, anything else in connection with Mr. Stargell allocuting?
No, Your Honor.
Okay. Take a seat, please. So I do find that Mr. Stargell violated a special condition of probation. I'm going to talk about why I find that, what that condition was. I'm going to get on the record what's already in the record, which was what I said specifically and explicitly about this. I have a few thoughts about the credibility of a claim that I didn't think the family would see this in this day and age. And then we'll talk about how this is going to play out. So on April 22nd, when we were all together at the close of our time together, after I think it was mostly Mr. Steele helped me understand the NOLO piece that I was a little reluctant to, but ultimately came around to and sentenced you. On page 58 of the transcript of the proceedings, I acknowledge that you, Mr. Stargell, would have a sentence of 5 years probation. And I went on to say, and I'm reading verbatim, the most important special condition of your probation, most important, is that you are to have no contact with Ms. Hicks or her family. If that's where I stopped, your lawyers have a whole lot of traction. You didn't call her, you didn't write her. You're not that much of a knucklehead, to use your lawyer. I don't think you're a knucklehead at all. You didn't make that mistake. we'd be having a very different conversation. And you would very much be looking at a revocation of your first offender status and a year in custody. If you had sent an email to Ms. Stargell or a letter or in any way, Ms. Hicks tried to contact her directly. But I went on to say, that's no direct contact. Obviously, you don't reach out to them, and you didn't do that directly. But I went on to explain what I meant. And I'm glad this was in the transcript, because this is what I try to do every time I have a case where there is a no contact provision. Because to Mr. Rousey's point, in this day and age, it's just people might not think they're contacting someone directly when they post. But we quickly move into well, you knew what would happen, and it's reckless or negligent, simply not credible to believe that if you push something out into your universe of contacts, given the way your universe of contacts necessarily overlaps with Ms. Hicks and her family, that it's not something that wouldn't get out there, despite your best intentions. And it sounds like technically you didn't have blocks up on the Hickses because they had blocked you. That's fine. There were off-ramps on your information superhighway that were blocked so that your post wouldn't go directly to Claire Hicks or to her brother or to her dad. But there are an infinite number of off-ramps from your superhighway that go to people who then you have no control over. And you know that. And you don't know who they're blocking, who they're not blocking. And just the very nature of what I understand, how you ever even came to be into contact with Claire Hicks is evidence that you know people who know that family. And so something that you post publicly is going to move around. Same with your mom. If either of you really believed that it would stay in this private little isolated circle, naive, and frankly, I don't believe it. But I went on, in case there was that naivete, no indirect contact. Other than your lawyers, Mr. Stargell, no one you know can purposefully reach out to them, meaning the Hickses. Not family members, Mom, not friends. Hey, Claire, just checking up on you. Can't believe you said that about Mr. Stargell. If Ms. Hicks or her family are getting contacted or seeing social media out there that relates to this, and it flows back to you or people close to you, Mom, I'm going to see that as you violating this condition. Now, I didn't write this and you didn't see it. I didn't print it somewhere that's hard to find. I said those words to you in court minutes before you posted, minutes before your mom posted. So I am not stretching to say I find the state has demonstrated by a preponderance that you violated what I told you was the most important condition of your probation. They didn't break the law. I'm not putting myself at that level. You didn't get arrested, and you took those things down once someone had to fuss at you for doing that. I remain astonished that your lawyers didn't tell you in no uncertain terms, as forcefully as they could, do not be an idiot and post anything about this. Don't take a picture of me with a victory sign afterwards. Don't act celebratory. Don't act triumphant. A lot of references to God, especially in your mom's post. I guess Sermon on the Mount eluded you all. You turn the other cheek. If someone has wronged you, and it's clearly how your family is processing it, you don't triumph over that. You offer them something else. You don't turn it into a situation of ultimately justice triumphed. You moved on. I am almost as surprised of you with the victory picture with your lawyers as I am with some of the things that your mom posted, having heard what I told you, which is if your family posts something about this case and it gets to the Hickses, which it will if you post it, that's going to be a problem. It is a problem. You violated an important condition of your probation. I'm not taking away your first offender status. There's a reason why I gave you that. But if we are talking again about the topic of contact with the Hickses, then all bets are off. I am adding a special condition to your probation as a result of my finding that you did violate your probation. And you are going to spend the next 6 weekends in the custody of the sheriff of Fulton County. You will need to report to Fulton County Jail, not this Friday, but next Friday by 5 p.m. You'll be released by 5 p.m. on Sunday, and you'll do those as consecutive weekends. Don't miss a weekend. Be there on time. You don't have school over the weekend, so you'll need to get on down here from school, serve those weekends, and we really need to never talk about contact with the Hickses again. If you post something, your mom, your dad, about this case, that's going to land in the Hickses' lap. There's not a way, technically, that exists now to exclude a human connected to the internet from something that you post online. That's not you emailing a coach. That's not you emailing a friend. If a friend forwards something that you wrote to them, that's not on you. But if you push it out into a social media platform that's not locked down to you and where you can prove conclusively the only 3 people who could have seen this are my mom and my dad, but it's the people over whom you have no control, you have no control. And guess what? Unsurprisingly, that landed in the Hickses' lap at a time when they too were trying to move on. Not quite sure what that was. So you knew better. You should have done better. Your mom knew better. She should have done better. I'm not laying at your feet what your mother did, but the admonition went out to her as well when we had this conversation, and it didn't help things. And so I trust your parents want to continue to lift you up as you navigate what is, I understand, a complicated situation for you as well. But this was something that was unacceptable on a bunch of levels, most of all to the Hickses. I don't take it as a slap in the face to me. That's not how I ever process these things. I had moved on and frankly was surprised because the way you presented yourself in court and the caliber of representation you had, I thought this was the last thing that was going to come up, was a social media post about the case coming from you. I frankly was concerned about the kinds of things your lawyers flagged, which is the no contact provision is not meant to be a trap for you. But you stepped right in it all by yourself with your mom right behind you. That shouldn't have happened. It needs to not happen again. Any questions about that?
No, sir.
All right. Ms. McGillicuddy, anything else from the state?
No, Your Honor.
All right. Mr. Rousey?
No, Your Honor.
Okay. I will get that modified sentence out. If you have any logistical questions about what needs to happen, let your lawyers know. They can reach out to my staff, and we'll take it from there.
Just this Friday,
Not tomorrow.
not tomorrow, next Friday.
Correct.
Just report to the jail.
Yep.
They'll have the paperwork, or we'll get.
So they don't always have the paperwork. You actually walk in the front door like you're trying to post a bond or visit someone. But one, the final disposition amended or the revocation order will be in the docket. You'll probably want to have your client show up with it as well. And this has happened before. If the sheriff's people say no and turn him away, that's not Mr. Starger's fault. And so you'll just need to document that. You let me know, and I'll need to grease the skids. That's not going to be a further violation. Now, not showing up, we have no record that he came, anything like that. That's different, and that'll have a different universe of consequences. But every once in a while, the sheriff's team says, I don't know what you're doing. This isn't how this works. That's usually because there's someone new at the desk or whatnot, but it's not atypical. We do weekends in jail and a number of situations, and this is one of them. All right.
Thank you, Judge.
Thank you.
Judge, would you like for me to handle that order?
Yes, please. If you could email that to me, I would appreciate it.
Not a problem. They're crying. What you crying for? Oh no. What's this doing? Hey. You got my email officially set up now, so if
Oh,
you
good.
need anything, you can reach out to me.
Good.
You're good for tomorrow?
Yes, tomorrow is a mellow day. We're supposed to be in trial all week this week. Miss Smith worked her cases out. They didn't fall apart.
Well, yeah. So you're going to family?
Family's coming here,
When
but
does
yes,
this start?
July 1.
Good luck.
And then who's Adam's coming out?
No, Ellerby.
Ellerby's.
We're swapping.
When does Adams come out? Or she's,
End of the year.
I bet that's funny. Well, I gotta go in there and watch that sometime.
Did family law for a year and a half and you couldn't drag me back into doing this.
Shh, don't talk about it that way. You need to say you miss it and you're not going to get back into it now that I'm getting
Judge,
into
you
it.
got Judge, you're in the role that is the probably the best part of the three-headed triangle. You don't have to deal with the opposing counsel. You have to make the decisions. It's more of the pressure, but as a fact finder, the client management of family law is brutal.
You got those good like mediation skills.
We'll
The
see.
whole idea is trying to keep them from going to trial, just get them to settle. And not fight over dishes.
Yeah. One second. All right, so we have Mr. Moses's plea and Mr. Schoenherr's plea to take. And I'm fine going in whatever order works. Ms. Smith, do you have a preference since you're doing both? Okay. Did you, Mr. King and Mr. Brill, did you guys arm wrestle over this one?
I have complete paperwork for the court. I don't know if they need it. I know his client's in custody, so if they need to get somebody, if they need to move.
I haven't done paperwork, is there a police chief?
You don't need to do it for Mr. Moses, so why don't, you've got paperwork, let's do Mr. Schoenherr, and then we'll move on. It's a misdemeanor, so it ought to be quick. Thank you. Mr. Schoenherr, if you'll come on up to the podium, your lawyer's gonna stand in front of the little wooden podium, you're gonna stand to his side.
But there's only one term that the state and I are not in agreement with, and we'll just talk about that.
We'll get that all on the record once we are ready. Let me know, Ms. Smith, when you're ready. All right, I know, trial calendar.
If, if you have any questions.
There it is at the bottom. Okay, thank you.
Okay.
This is 25 SC 007275, State versus Schoenherr. Mr. Brill is here with his client, Mr. Schoenherr. Ms. Smith is here for the state. And it's my understanding, Ms. Smith, that this is a plea, but it will be a plea to a misdemeanor. Is that correct? Or misdemeanors, but it's now a misdemeanor plea.
Yes, Judge, that's correct. Count one will be reduced to disorderly conduct and count two will be no cross.
All right,
CGA code for disorderly conduct is 161139.
got it. Mr. Schoenherr, in just a moment, Ms. Smith is going to put you under oath and then proceed to ask you a bunch of questions that overlap nicely with the form that you and Mr. Brill just covered. You need to be sure to answer her questions truthfully and completely. If at any point during our group conversation, you have questions or you reach a point where something isn't going the way you thought it was, you're confused, let Mr. Brill or me know. Will you do that?
Yeah, absolutely.
Okay. Ms. Smith?
Thank you. Mr. Sternair,
I'm not sensitive to that, but
Okay.
thank you.
please raise your right hand.
Oh, okay.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Scott John Schernhair?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given today?
Okay, that I haven't. No.
Okay.
Is there medication that you normally take that you did take today?
Yes.
And does any of the medication that you take when you take it cause you to be drowsy or disoriented or just a little uncertain of your surroundings?
No, not at all.
Okay.
How old are you and how far have you gone in school?
I'm 60, and I have a PhD in clinical psychology.
Are you able to read, write, and understand the English language?
I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, I have.
Do you need more time to discuss your case with your attorney?
Not at this point.
And are you satisfied with his services?
I am.
Counsel, are you satisfied that your client understands the understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Yes, so waived.
Mr. Sternair, do you remember being arrested on these charges?
I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months to serve 15 days with the balance probated?
I do understand that.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge that you're pleading to today?
I am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history unless it is accepted by the court under First Offender Act?
I do.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes,
Are you a United States citizen?
I am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
I am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
He has.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
I do. Could you repeat that? Because it's such a serious statement.
Yeah.
It is.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
Yes.
It stays a misdemeanor, so you understand if, I don't expect this would happen, but if while you're on probation, you do something that I ultimately conclude was a violation of your probation, the state could advocate for, and I could decide to revoke your first offender status and then resentence you for what you pled to, which is disorderly conduct.
Okay.
And so the most I could sentence you to would be the sentence for that misdemeanor, which would be up to 12 months, although it would probably be less because you would have served some time on probation. And so let's say there were 8 months remaining in the 12 that you got. If what you did was serious enough, I could say, there goes your first offender, and I'm sentencing you to the 8 months. the felony doesn't get resurrected.
Yeah, I have a specter of that.
Sure, and that's why it does sound, and it is serious, and you need to understand it, that first offender isn't all warm and fuzzy. It has a risk to it if staying out of trouble is going to be complicated for the first offender. But it would not empower the state to bring back the felonies. We would leave here today with you as a first offender probationer on that misdemeanor. The felony from which it came, the aggravated assault, would be forever gone, and the state is dismissing count 2. They couldn't undismiss it. The state is, I don't think they're taking a gamble, but they've assessed the facts and more about you and have said, we're comfortable turning this case into a single misdemeanor.
Right.
And if it really went poorly for you, the most it could be would be 12 months in custody.
All right.
Does that explain it?
It does very well, and I appreciate that greatly. I have some clarification that any violation of the probation would be it would be if it was a substantial violation, not a minor, a thing like if I get a traffic ticket or, if there
So
was
I don't want to mislead you, but generally the sanction would be proportionate to the violation. I would be surprised if the state came to me to say you should revoke Dr. Schoenherr's first offender probation because he got a parking ticket. If you got a DUI,
sure,
they might.
I would.
If you do anything with a firearm, I would expect.
Yes.
And be frustrated if they didn't.
Yes.
Hey, Schoenherr got arrested with a gun again. That would be the type of situation where you should expect, if the state proved it up, that I would revoke every day I could.
I believe that.
But if you jaywalk, it probably wouldn't even result in a hearing.
All right. Okay. Thank you.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea today?
I do.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, I understand all of that.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Schoenherr, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 007275, how do you plead to the reduced count of disorderly conduct in this indictment?
I plead guilty under the terms of Alford v. North Carolina.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
I do.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
I do.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Judge, if this case were to proceed to trial, the state would show that on November 26, 2024, officers of the Atlanta Police Department responded to 338 Greendale Drive, Southeast Atlanta, Georgia, also in Fulton County. When the officers got there, they spoke with Montavious Farmer. He advised the officers that his child, Centavia Farmer, was outside with their dog when their neighbor, the defendant in this case, pulled a gun and pointed it at his daughter. The officers then spoke with Centavia Farmer at the time she was 14 years old, and she advised and told the officers that the defendant pulled out a gun and pointed it at her and then pointed it toward the air. Centavia told the officers that they were outside, and when I say they, she mean herself and her brother. They were outside playing with the dog, running around when they encountered the defendant. They stated that their dog ran toward the defendant's dog in this case. The defendant's dog was right next to the defendant. At that time, the Miss Farmer stated that her and her brother ran after their dog to grab it. And that's when the defendant stated to the kids that if the dog continues to run back to his dog and him, that he would shoot the dog. After he made this statement, Miss Farmer stated that he pulled out a black gun, pointed it at her, and then pointed it toward the air. At this time, the officers on the scene, they did a bit of an investigation and they got a chance to speak with the defendant in this case. They walked over to the defendant and they kind of, to set up the scene here, they kind of live right across from each other in this neighborhood.
Across the street or literally like yard to yard? They're adjacent.
Across the street, that's correct.
Yes, it's across the street.
Okay.
So the officers went over to speak with the defendant, who stated that he did encounter Miss Tavia Farmer and her brother, and that they've had ongoing disputes before this about their dogs and the Mr. Farmer's dogs biting his dog, or just disputes within the neighborhood. He said that at the time that he encountered the kids, he did not have a weapon on him. He did acknowledge that he carries a weapon inside of a black backpack, but at the time that he spoke with or talked to Centavia, that backpack was in his book bag. The officer stated that based on the statements from Centavia Farmer, Montavious Farmer, and everyone else who was at the house, and with the assumption that he did have on a backpack at that time and carried the gun, it was more than likely true that he pointed the gun at Miss Farmer. So because of that, on that day, the defendant in this case was arrested for the crime, the charge we have in front of us. At the time, Mr. Farmer stated, and when I say Mr. Farmer, I'm talking about the victim's dad. Mr. Farmer stated to the officers that he had a ring camera footage that could have captured the incident or the shooting, pointing the gun in this case. The officers did look at that body cam. However, we can see, or the officers were able to see, that the defendant went behind like a trailer. Someone in the community drives an 18-wheeler. He parks his truck on the street. So the defendant went behind there, but we can't see anything that happens. I spoke with the defense in this case when we talked about resolutions, and he gave me some discovery about an affidavit from one of the neighbors who stated that she saw the event and she saw what happened. I reached out to her and she told me that she is a neighbor in the community, that her house in a way looks over Mr. Shonier's house and Mr. Farmer's. And she was able to see that on that day, the defendant did step behind that 18-wheeler when he was having an interaction with Miss Farmer and their dog. And he pulled out a phone from his back pocket that was not a gun. And the defendant stated, "Hey, I'm going to record this if your dog continues to run over and tries to attack my dog." Because of that eyewitness testimony and the facts and circumstances of the case, the state did decide to reduce this case to disorderly conduct. I had a chance in this case to speak with Mr. Farmer, who is the father,
dad.
Yep, the father of the victim. He told me that, of course, that's not their series of events and how they believed it happened.
And
However,
I'm sorry to interrupt, but Mr. Montavis Farmer, he didn't see any of this.
Correct.
It was reported to him by Centavia and her brother.
that is correct. So he said he understood, why the state was reducing it. However, he did want to be heard today. I sent him the Zoom link. I called him before again. He said that he would log in and that he would make a statement when it's appropriate. But those are the facts and circumstances of the case. Regarding the negotiated plea in this case, we've agreed to a sentence of 12 months to serve 15. He's already served the 15 days. So, credit for time served with the balance probated. Regarding the special conditions of probation, the state is asking for an anger management course for there to be no violent contact. Only reason why I'm asking for no violent contact is my understanding.
Their neighbors.
He doesn't stay there, but he goes there frequently.
Okay.
It's his home, but he goes there frequently because he has a gardener, things he tends to at the home. And the state was going to recommend an apology letter. I do understand the court's understanding, or, how we feel about apology letters. I believe the defendant in this case has already written an apology letter. So if that can be accepted, that's fine. If not, we totally understand. But those are the special conditions of probation that the state is asking for. We're also asking for, after the anger management course has been completed, that this probation turns into non-reporting. But that is all from the state, and I don't know if the victim's dad is on, but if so, he would like to make a statement.
He's not. I looked when you mentioned that, and we have Ms. Bostic from pretrial and Ms. Simpson from DCS, but that's it.
Okay, I'll check with him.
Okay, all right. Well, if he manages to appear before we finish, we can take it out of order, and that's fine. I don't want to deny him that opportunity. And we did shift things around a little bit. It was going to be at 2, and here we are at 2:38. So, Ms. Bostic, do you have any criminal history information for Dr. Schoenherr?
Judge, his only prior arrest was a DUI in 91, and it was a conviction. Nothing further.
Thank you. All right, Mr. Brill?
Your Honor, I had a little bit longer speech, but I think the state really nailed it. And I think that's why, honestly, I do appreciate them looking into the discovery we provided some extensive discovery that was collected in large part by my client. Your Honor, kind of to a lot of what has happened here, I think, is a lot of the neighbors, the farmers haven't really understood why or who Mr. Schoenherr is when he moved in. He bought these tracts of land in this location in 2012, kind of after, and was trying to turn them into kind of a nature preserve. He hasn't really been living there. He's been basically rebuilding a home and trying to resuscitate an old piece of property there. So he hasn't been there permanently. I have to say, when the police arrived on scene after the child told her father, the actions of the Atlanta Police Department kind of inflamed some of the back and forth. It is completely understandable when Mr. Farmer is receiving a situation from his daughter saying, "Hey, this guy just pointed a gun at me, threatening my dog." He's going to be pretty irritated. But when they made statements to the effect of, this is how they brought up.
The police made these statements?
They brought up shades of Trayvon Martin. They implicated that he was a member of a Cop City protest. They kind of made a lot of statements about who Mr. Schoenherr is, and he's just not that guy. And what we wanted to make sure the record indicates is he really just wants to be a really good neighbor and wants to live as he's been living, because originally he was denied bond. He nearly suffered a very serious health issue while he was in Rice Street. I was retained in visiting him, and we were able to get a consent bond from the DA's office. But after we modified that bond for him to go back to the property, he's been able to go back to that property and has had no issue with the farmers for the past 7 to 8 months. So obviously he's going to have no issues abiding by the terms and conditions of the probation. And all he wants to do is be a good neighbor. That's why he really likes this area. He likes this property. This situation was, the dog did attack him. The dog that owned by the farmers did attack him and his dog, and he was in a situation where he was trying to pull his dog back. I do believe that Centavia made an honest mistake. She saw his cell phone and she thought it was a gun. I don't believe that he threatened to shoot the dog. I think the statement that we would have presented at trial was, that is a good way for a dog to get shot, which is a difference of opinion. Anyway, there is a very, very large risk that a minor child as a witness is not the best type of witness you want to put on the stand and risk going to trial on an aggravated assault charge with how that statute reads. My client is coming with open hands here. He completed a gun safety course, which we would ask the court, that's the only disagreement we have. We would ask the court to accept that in lieu of anger management, because my client has no history of being outside or an angry person or exhibiting any anger in this situation. He has actually exhibited, we provided some discovery where he has tried to, throughout some of his neighbors, kind of diffuse some situations in terms of cleaning up some property and cleaning up the property around him and trying to assist the owner of the 16-wheeler. But I think that's a requirement that's unnecessary, as well as he completed the gun safety course that we can provide to probation. He did write the letter of apology for the situation and his role in it, because we were trying to work towards a dismissal in this case, but we do, and through negotiations, do believe this is a reasonable way to handle this case. We would ask the court to accept this under the First Offender Act. And I did email Ms. Nelson and Ms. Smith a proposed order to that effect to seal it at the time of the plea. My client's 60 years old, and when he was 26, he did get a DUI, which back in 91 was part of I think, what would now be termed an illegal roadblock situation. But ultimately, I don't think that has any impact whatsoever on his activity today. He's a clinical psychologist, and that's why both first offender and the Alford plea were not only considered, but basically based on the facts, he intends to, he's not currently practicing day to day, but wants to maintain his license because that's very important to him. That's who he is. And ultimately, that situation, especially how the farmer saw him that day, is not who he is, not who he ever wanted to be. And this situation has frankly impacted him, certainly negatively, but I think through him viewing all of this, all he wants to do is be a good neighbor towards them. So we ask to accept all of the conditions of that were laid out between us and the state, and to accept, it's in lieu of anger management, the gun safety course that he has already completed, and that basically we issue a sentence that he's just have no violent contact with the farmers to complete the gun safety course, to do an apology letter, because I think that's relevant, and to find that under the First Offender Act.
Thank you. How would first offender work here, given that he has a DUI? Is he not on the misdemeanor side, he's not first offender eligible?
So my understanding of the First Offender Act is a misdemeanor conviction. Only the way that the First Offender Act is written does not actually impact first offender from being utilized for another conviction. That is my understanding of the statute as it's written.
Okay.
I don't think, for one, DUI is not part of the is not eligible first offender under any circumstances whatsoever. So you can utilize first offender for any charge that's not specifically prescribed by the statute, or if you are somewhat eligible as under the statute. But a DUI, a misdemeanor conviction, does not make you ineligible to utilize first offender even for a misdemeanor conviction. You are able to, even if you had multiple misdemeanor convictions, that still does not make you ineligible to utilize first offender for a charge, whether it be a felony or a misdemeanor. I think that the first offender statute is only enabled to be utilized for conviction if it has been previously used, or if you have been previously convicted of a felony, or it is a specific felony that is designated as not being eligible for first offender treatment.
I've never run into this fact pattern. Not the gun and kids and dogs, but the language of 42-860 starts with, it's a very long statute, but the first clause is when a defendant has not been previously convicted of a felony. It goes on to say you can do these things. I know you can use first offender for a misdemeanor. That certainly there's precedent for that. And it doesn't say as long as they haven't been convicted of a misdemeanor. It's peculiar, but I sort of get it, because I guess the legislature is saying if you haven't had something as serious as a felony conviction, you've got this ability for the appropriate offenses, not a child molestation, to use this privilege. And it may be that you use it on your 9th misdemeanor. And here it would just be the 2nd misdemeanor. Do you know anything in the law to the contrary, or have a legal concern about a first offender sentence for a misdemeanor when a defendant already has a misdemeanor? Ms. Smith?
No, Judge, that was kind of my understanding of it also.
Okay. I think that's an accurate read of the statute. I just don't know that the legislature necessarily contemplated. It would be clear if they said and you can use it on a second or subsequent misdemeanor. But I don't get the sense this case is going to generate an appeal. So we'll leave it as we all understand it.
Your Honor, I think that ultimately the statute, and I think the legislature made the fact finder in terms of the court there because it's discretionary. A first offender is always discretionary. So if there was ever an issue, the court can always say, well, no, we're not going to allow first offender treatment.
Well, it's discretionary where it's allowed.
Right.
I might think that your client, not this client, is really deserving of first offender. 17-year-old, never been in trouble, want to keep the rest of his life not burdened by a felony conviction. But if it falls on that list of prohibited offenses, I don't have discretion there. So it's discretion within the universe of first offenderable offenses. And I just wasn't sure if a second misdemeanor was a first offenderable, it's going to be a great transcript, offense. And we're going to say it is. Okay.
Judge, I believe the victim's status on this.
All right, Mr. Farmer, good afternoon, sir.
Good afternoon, Your Honor.
I appreciate you joining us. I'm sorry that the time bounced around a little bit. I'm going to add you to the call here. Let me get you up to speed as to where we are. Dr. Schoenherr is here. He is entering a plea to a disorderly conduct charge. Ms. Smith, the prosecutor, shared with me the allegations, what happened to your daughter and maybe your son when they had an interaction with Dr. Schoenherr concerning the dogs, yours and his. And Mr. Brill, who is Dr. Schoenherr's attorney, has given the other side of the story, because there are always two sides to the story, just to give me his client's perspective. And then I was just working through a few of the steps I need to, but you have an absolute right to share with me the impact this has had on your children, on you, your household, and your perspective as to how this ought to shake out. You should know, and I think you do, from the prosecution, the district attorney's office has already made a decision that they get to make. That's not my call, it's theirs. They're dismissing one count and they've reduced the aggravated assault, which is a felony, down to the misdemeanor of disorderly conduct. That's a decision solely within their control. And so I'm working through, should I accept the plea to the misdemeanor? And if I do, what does that sentence look like? But I'd love to hear from you if there's something you want to add.
Yes, sir, Your Honor. I just asked that when he come around, he treat my kids and my family with respect. This is like the first time we had a run-in with him. That's all I ask.
That is a very reasonable request.
You know, my kids, they terrified him. They don't even come outside when he pull up. First of all, he don't even stay in that house. He come over every day. You can't even see the house. There's so many bushes over it. The grass taller than the house.
Okay, well, that might be a municipal court matter if you want to bring up any code violations there, but your request about respectful civil interaction is spot on, and that's going to be part of how I structure the sentence here. So this happened about a year and a half ago. Your daughter now, maybe 16, how's she doing in high school?
She's doing great. She was a straight A student. She can attend today. She had to go to orientation.
Good. I'm glad she's doing that. And your son, I didn't catch from the conversation I had with the prosecutor. Is your son older or younger than Centavia?
He's 14 now.
Okay. So he's the age she was at the time. So is he just finished up middle school?
Yes, sir, Your Honor.
Great. And where does your daughter go to high school?
South Atlanta High School.
Fantastic. And so your son will be starting there in August?
Yes, sir, Your Honor.
Good. All right. Mr. Farmer, anything else you want to share?
No, sir.
All right. I appreciate you taking time from work or wherever it is you're in the middle of. Please let both your son and your daughter know that they were heard through you and that I appreciate how this was a frightening situation for them.
Yes, sir. Thank you, Your Honor.
All right. Take care.
All right.
All right. Had you finished? Yes, because I was asking questions about first offender. Dr. Schoenherr, tell me what you do when you're not letting the grass grow too long down Greendale? Are you
What I do with my days?
yeah, are you employed now or are you retired?
I'm semi-retired. I have this property, which is 5 acres. It's a food forest in parallel to the Browns Mill food forest at 7 acres that the city's doing. So I work on that, and then I'm trying to salvage that old homestead. I'm in love with the property. There's nature, wildlife, deer, little river otter, things like that. So it's really charming with the creek.
Is it a larger parcel than some of the adjoining ones, or would, for example, the farmer's property also be 5-6 acres with a lot of nature?
No, they were divided, and then I was able to put the parcels together when.
I guess that's what Mr. Brill said, is you bought a number of parcels and have combined them to create, I'm gonna call it the preserve.
A 5 acre, my friends call it the farm.
Okay.
And so, yeah, so I was able to put that together for about $22,000, when nobody wanted the properties, about 8 years, whatever it was, 2012, yeah.
Okay.
So I work on that, and then I have my own house, which is kind of dilapidated that I'm working on. And then
on one of the Greendale parcels is where your house is?
No, in Southwest Atlanta, in Capitol View.
Okay, completely different neighborhood.
Just about 5, maybe 7-minute drive away. And then I bought several properties during the Great Financial Crisis when they were $17,000 or $10,000. I didn't get them all that cheap. And then I've sold a couple, and I worked on them, interested in, learning to do rehab and things like that.
Okay.
So I did that, and that's what I work on. And then my passion is writing because, that's something I think, given my education and thinking about philosophical sorts of issues. And what I've told people is I'm smart enough to know I'm not crazy with some of my ideas. So I'm, putting those out there on the Substack, things like that.
Got it. So at the Greendale property, you do have neighbors. The farmers are one. How many are there? 10 other houses around? I don't know the street. I just have seen it on a map. It's near Southview Cemetery. But I'm curious if that street is basically you and the farmers, or if there's clearly one other neighbor, because Ms. Smith talked to that neighbor who gave a different version of events than what was shared with the police initially.
Sure, and I think as early as the 2007, 2006, there wasn't even a paved road. Habitat for Humanity came in, did a development of about 30 properties.
Oh, fantastic.
It's a wonderful development.
Okay.
And, they changed their design styles where they actually added more architectural details and things. So the homes are really nice. And it's across the street from me. And that's where the farmers are. They're part of that development. I bought this property across the street, and by putting those lots together, I have 175 feet to my left, 175 feet to my right, and then it goes back about 400 feet.
Okay.
And then down the hill from me, there's a neighbor, I think related to the Andrew Young, one of their family members, and they have like a 3-acre sort of estate. And then to my left, there was another property that 175 feet, and then the houses pick up there.
Okay, got it. All right. Do you have any questions about anything Ms. Smith said or your lawyer said?
No, I mean, there's things that I think I might add a little detail, but if
that's up to you. This doesn't need to turn into a he said, she said.
Yeah.
My view of this is that something happened that was pretty upsetting to Centavia Farmer and her brother.
Yeah.
That's a problem. But I need to work through your connection to that and the consequences for you. They've related one way, a neutral third party has related it one way, and you're going to have a different perspective. I appreciate Mr. Farmer joining us, and his request was not, you should be buried under the jail. It was, let's treat each other with respect. And for whatever reason, he and his family have felt that your interactions with them haven't been respectful. I'm not taking a side on that. You got to hear it from him. And so my hope is, insofar as you remain an active, good neighbor in that neighborhood, maybe bridges can be repaired.
That's my hope.
The condition of probation is not no contact with the farmers. It's no violent contact. And that should be easy. And you will decide and the farmers will decide, might it evolve in a way where you don't need to be best friends, but it's a way where people are civil to each other. That's my hope. You're in the same neighborhood. You may want to engage them on, talk to me about your concerns about the height of the grass. And they may better understand it's actually not grass, it's corn you're growing or something, because it sounds like you are using your land in a different way than a number of the people in the neighborhood. And they might look at it as, why don't you have a lawn and a tree and a front porch? And there may be a great reason why you don't. But people talking productively can start to understand that's not a bad thing, it's just a different thing. And what the heck, we're going to get tomatoes and cucumbers from what you're doing. And all of a sudden, oh, you're a good neighbor, as long as if I go get those tomatoes, I don't get a gun drawn on me. And from your perspective, as long as when I, meaning you, am visiting my land, a pit bull doesn't come running at me.
Yeah.
Because there are dogs that can be scary, whether it's yours or theirs or someone else's. And that's all part of being in the same community. They can't make you move, you can't make them move. We might as well try to have it be as civil as can be. And that's what I heard Mr. Farmer say. And that is a well-grounded request.
Yes, I was delighted.
So I didn't mean to talk you out of adding more, but I don't know that there's a whole lot more we need to explore concerning the incident. I wanted to make sure you were clear on what the lawyers were saying in terms of the legal consequences and your rights and things like that.
And maybe despite my better judgment, just this critical thing, because I think it was sort of a tragic mistake. Not that the children were frightened, I'm not doubting that, but the interpretation of my dog pulling back on the leash is on my right hand. I'd put him down, check him for wounds. He was pulling back to get onto my property. I enter back there. I always do for security. My gate is triple locked and bolted from the inside. So I can't go that way. I always go back for security because there's some theft and danger in the neighborhood. Dog's pulling. So I look back and then she has come towards me from where she was. I thought it was resolved. So I yanked it. I'm in a crisis. I yanked the dog back to create slack in the leash.
Got it. And you're making a movement that
yes.
Folks who watched too much TV or have had trouble in running into unfortunate situations in life would say, you just pulled something out of your waistband.
144 feet away. I measured it with a measuring wheel.
Okay.
Got the phone out of my pocket, had to yank again. This is a husky. He pulls to get it to my face. She was gone. So I just wanted to add that detail.
Okay. Well, I appreciate your perspective. I also appreciate that we had a couple kids who were pretty alarmed by how that went down. I'm glad to hear they're both doing well. Straight A student in high school, and now they're about to get into high school. And again, maybe over time they'll feel a little more comfortable circulating in the same spaces as you.
Yes.
And you'll feel more comfortable being around their dog. We'll see how that plays out. But it takes two. It takes two to make a relationship work. Find that there's a factual basis for your plea, given what the state is now charging you with, and that your plea is knowing and voluntary. Knowing means you've understood the things we talked about, and when you didn't, you did what I asked you to do, which was ask questions, and then you said, I get it, I understand. Voluntary means no one's forcing you to enter this plea, but you've decided it's in your best interest, and that's actually the type of plea you're taking, is a best interest plea, which I will accept. Sir, you filled out a form with Mr. Brill, had a bunch of questions that needed your initials, and ultimately, at the end, there was a page for you to sign. Did you sign on page 4, the plea of guilty form?
I thought I did.
You did? I want you to confirm that's your signature.
Oh, I'm sorry. I thought it was maybe blank. It looks like from here that's my signature.
You did sign it, and you talked about it with Mr. Brill.
I did.
And Mr. Brill, you signed it as well, only after confirming your client understood its contents.
Yes.
Mr. Brill, can someone in my office sign the indictment indicating your client's offered plea to the state's charge reduction?
Yes, they have my permission to do so.
Ms. Smith, can someone sign for you?
Yes, Judge.
And Dr. Schoenherr, can someone in my office sign for you?
Yes.
We'll do that. So I am going to sentence you to 11 months probation. You serve 15 days, but rather than do 12 months minus 15 days, let's just keep it in we'll denominated in months. You've got 11 months of probation. You have 2 weeks once your probation starts to get your probation proof of the gun safety course. If you haven't done that, then you have 1 month to complete an anger management course. So it's a conditional condition. If in those first 2 weeks you convince probation through some satisfactory proof that you completed a gun safety course, there's no anger management requirement.
All right.
But if you don't, or they say you got that from a cereal box, then you'll take an anger management course. More important, you have a condition of no violent or tumultuous contact with any of the farmers. I don't know if there are others beyond Mr. Farmer who joined us, his son and his daughter, but their household in your household are near each other, and or at least the farm, the property, and you're there some. When you're around, if they happen to be around, you have an obligation to walk away from a situation if for whatever reason it's seeming like it's getting out of hand. That is your burden during the time you are on probation.
Yes.
Okay? And as long as you are a first offender probationer, and I am sentencing you as a first offender probationer, no firearms. When you're done with your probation, you may lawfully have a firearm again because this is not a felony. It's also not a conviction. But while you're on this probation, no firearms.
Okay.
Okay? That doesn't mean you have to walk through life unarmed if you feel the need to carry something for protection. It just can't be something that fires a projectile.
And so there's custody of my weapon, of the gun, in police custody. Should I just leave it there for this period?
So you should talk to Mr. Brill about his experience with police evidence. My thought there is that's a safe place to keep it. But if for some reason APD, was it the Atlanta police case? They learn, hey, this case has been resolved, they might bend it into scrap metal, and then you wouldn't be able to get it back when the case is over. So you might want to have Mr. Brill get me an order that requires the Atlanta Police Department to release it to someone not named you.
Okay, gotcha.
And then that person who doesn't live with you could be the person who maintains custody of that and any other firearm you might have, because this restriction is unrelated to Greendale. It is related to you and the space you move through. So you mentioned you've got a home that's 5 minutes away. That home is firearms free.
That's the case.
And so any firearms you might have, whether it's the one in police custody or elsewhere, needs to be held by someone else until your 11 months of probation is done.
Okay.
Mr. Brill, there's a form.
Sorry, Your Honor.
Excellent. All right, Doctor, this form gives me all the necessary contact information that my staff will send to Judicial Correction Services. Misdemeanor probation is actually run by a private company. And they will contact you based on this information. Call them back or email them back if they don't get you directly, because you don't want them reaching out to me saying, we can't get this guy's attention. Once you plug in with them, that process will be started, and we'll go from there. I'm going to leave the probation as reporting probation for the full 11 months, mostly to keep that no violent or tumultuous contact condition in place. It sounds like you are going to be someone for whom remote reporting is going to be something they sign off on almost immediately. If you find the conditions end up being problematic, you let Mr. Brill know, and if we need to have a probation modification conversation, we can certainly do that. Okay?
Is that like a weekly or monthly thing? You know?
I don't. Never been on probation. But my understanding is that it's not particularly burdensome, and you can make it less and less burdensome by being responsive to when they reach out to you.
Sure, absolutely.
Okay. Ms. Smith, anything else from the state? Nothing further. Mr. Brill, on behalf of your client?
No, Your Honor.
All right. Thank you, everyone, for your time.
Thank you.
Thank you, Your Honor.
Mr. King?
Yes, sir. Have a nice afternoon. Good.
Can you get Mr. Moses?
Can we do it on, I'm sitting down and don't have nobody.
Yes, whatever works for you. You could all go back there if that's easier.
Is Laura still working with, Richardson?
I think so. I haven't seen her in a long time. Let me look.
You don't really see, you see the people on your floor.
Right, you exactly.
You know, Samantha went, she probably.
Huh? Hello, Mr. Moses. Well, if you take a seat next to your attorney, Mr. King, please. You get to. Oh, you want to ask your attorney some questions? Sure. Yes, Laura still works with her.
We're ready, Your Honor.
Okay. Give me 1 second. Okay, let's get on the record. This is, let me find Mr. Moses's case. Thanks. You never give me any time. This is 25 SC 004-517, State versus Moses. Mr. Moses is here visiting us from Washington State Prison. His lawyer, Mr. King, is here. We have Ms. Smith for the state. And Mr. Moses, I had a conference with Mr. King and Ms. Smith this morning, where Mr. King gave me a little more info about you and where you are right now with this case and your thoughts. And I believe this is a non-negotiated plea. Is that your understanding, Ms. Smith?
Yes, Judge.
Okay. And I also believe that you have, I know because I see it now here, you still have your final plea rights. Let me tell you what that means. We'll get through the plea. Ms. Smith is going to recommend one thing. Mr. King is going to recommend another thing. They're both that, recommendations. Neither one of them controls what I do, but they certainly inform what I do because Mr. King knows you better than anyone else in the room. Ms. Smith knows this case very well. Ultimately, I'll pronounce a sentence. If the sentence that I hand down is in any material way more severe than what Mr. King asks for, I'll let the two of you talk. And if you want to withdraw your plea, you can do that and we'll do a trial in this case. Not today. It probably have to roll over to the next trial calendar. But I want you to know you'll have the right to back out, to withdraw, if the sentence that I impose is more severe than what Mr. King asked for. Just as real simple math. If he asked for 1 year to serve, Ms. Smith asked for 2 years to serve, and I agree with Ms. Smith and say 2, or I'm in the middle somewhere, 1 year and 3 months. You two can talk about it, and you can either say, it's not what I want, but I'll take it, or no, thank you. 1 year was what I was willing to take, short of trial. And if that's not what I do, you can have trial. Does that make sense? Okay. You mentioned when you came out into court that you had a couple more questions for your lawyer. Did you get those questions answered? Okay, you're ready to go. All right, Ms. Smith is going to put you under oath. Once you're under oath, please answer all her questions truthfully and completely. And then keep letting Mr. King know or let me know if you've got any questions, okay? All right, Ms. Smith.
Thank you. Mr. Moses, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Can you speak up a little bit or maybe bend the microphone down?
Willie J. Moses.
Is it on?
I don't know if it's on. Is the green light on?
Yes.
Okay. All right.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medication.
What medications are those?
Well, I'm taking insulin, and I'm taking metformin. I'm a diabetic.
Do any of the
I'm
medication?
taking high blood pressure.
Okay, I know, my bad. I didn't mean to speak over you. Do any of the medications that you take make you woozy or drowsy or confused?
Drowsy, woozy, not so much as confused.
Okay. Do you feel like you understand what we're doing here today?
How old are you, Mr. Moses, and how far have you gone in school?
67. Well, 66. I'll be 67 in September.
How far have you gone in school?
Oh,
Did you finish high school?
Are you able to read, write, and understand the English language? Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
yes, sir.
Do you need more time to discuss your case with your attorney? Okay. And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes, we do.
Mr. Moses, do you remember being arrested on these charges? The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court? Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge? Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history? Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case? Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today? Are you a United States citizen? Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment. Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense? Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea? Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, The right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney. The right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges. The right to testify on your own behalf or remain silent. The right to present other evidence of your own and call your own witnesses. And the right to appeal if convicted of these charges after a trial. Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes, I am.
Mr. Moses, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today? As to indictment number 25 SC 004517, how do you plead to count 1, theft by receiving stolen property, and count 2, identity theft fraud when possessing or using identifying info concerning a person? Guilty or not guilty?
I'm guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Do you understand that that process must be completed within 30 days from today? Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Thank you, Mr. Moses. Your Honor, if this case were to proceed to trial, the state would show that on July 30th, 2024, Officer Board of the Atlanta Police Department responded to a stolen vehicle call that was at the Atlanta airport. When the officer got there, they spoke with the victim, Ms. Dana Lewis, who informed the officers that her white 2018 Porsche was parked at the parking garage at the Atlanta airport when she went away for her trip. But when she came back, the car was no longer there. The person in charge of the parking garage assisted her with trying to find her vehicle, but she was unsuccessful. She told the officers, Ms. Lewis, she told the officers that she may have dropped her key fob because she couldn't find it anymore, and the parking ticket was inside of the vehicle. So it was more than likely that the car was stolen. At that time, they did a report and put out a BOLO for the car. Almost 3 months later, on October 10th, 2024, officers of the police, officers of the Atlanta Police Department, they were on patrol when they saw the same car, that 2018 Porsche, exiting 1919 Metropolitan Parkway Southwest, that's in Atlanta, Georgia. That's when they saw the car. They pulled the car over because they had that information from the BOLO hit. When they pulled the car over, the person that was driving was identified as the defendant in this case. The officers asked, because they knew the car had been stolen, where Mr. Moses got the car from, and he stated he got it from someone he had been knowing for about 6 months, and that he only had the car for a couple of days. The officers then asked Mr. Moses to call the person who he got the car from. However, he was unable to produce either a number for that person or get that person on the phone to get more information about where they got the car from. At that time, the officers asked Mr. Moses to step out, seeing that he was the driver of this stolen car. When the defendant got out, the officers were able to retrieve multiple driver license from his person. There were a couple. There were 2 that had his pictures on it, but there was one from Georgia and one from, I want to say, New York, and the New York driver license had another name on it. So it was his picture, but it was another name. Also a part of those driver licenses that they got, it was multiple, it was different licenses with different people's pictures and names on them, all not relating to or being Mr. Moses or being the correct driver license where the officers checked it out. So because he had on his person driver license that did not belong to him and were obviously altered in some type of way, and because he was in a stolen car, Mr. Moses was arrested for the charges we have in front of us. And those are the facts of the case. I did get a chance to speak with Miss Dana Lewis, who is the owner of that 2018 Porsche. And she told me that through insurance, because this happened a while ago, but through insurance, she was able to get a new vehicle. She's not asking for restitution in this case. I did send her the Zoom link, but she said she did not want to be on the call, but I could just give her a call afterwards to let her know how the court date went. Regarding the recommendation in this case, the state is going to be asking for, on count 1, 10 years to serve 2, and also on count 2, 10 years to serve 2, those to run concurrent for a total of 10 years to serve 2 with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to complete an anti-theft course, for the defendant to pay a fine of $500, and also for the defendant to have no contact with the victim. I know in this case that the defendant may not know who the victim is. However, when I spoke with her, she said because he may get her name through discovery and things like that, she would just ask for no contact with the defendant in this case.
Okay.
And that is all from the state, Your Honor. Oh, also, I would say that I did double check. I did file a recidivist notice in this case, and I am going to be withdrawing it for the purposes of this plea.
So if Mr. Moses rejects the plea and goes to trial, you would reinstate the recidivist notice.
That's correct.
And it looks like he would be an A and C recidivist, which would require the sentence to be the maximum. I don't necessarily have to sentence him in custody for the max, but any amount to which I did sentence him, he would have no possibility of parole.
That's correct.
Okay.
And also, Judge, I'm sorry, I forgot to give a little bit more basis behind the state's asking for 2 years in custody. We looked at the defendant's history in this case, and the state was a bit concerned with the risk of reoffending. The defendant has a history dating back to 1984 with a theft by deception conviction, and also 2 theft by receiving stolen property convictions from 2007 and 2016. The defendant has a conviction for forgery from 2008, and 2 different separate cases that were both handled on the same day for ID theft fraud, which is one of the similar charges we have here, back in 2020. In that case, the defendant was sentenced to 10 years probation, but I wanted to highlight that one of the cases that he got the 10 years for probation, in that case, there were 20 counts of ID theft fraud. And that was just one case, and it was all handled on the same day. But in that case, it had multiple charges, and 20 of those counts were for ID theft fraud. While the defendant has been on probation for that case back in 2020, he's been arrested for this case that we have that happened in 2024. And the defendant was arrested in Fulton County back in July of 2025 for theft of services and unlawful possession of an altered ID. That both for those charges are misdemeanors, so they're not in our court. I did check; it's not an open case or been indicted, but it was just an arrest that the defendant had. And the state believes with the 2 violations that he had after receiving a 10-year probation sentence and the plea that he took in that case, it just raises concerns of the risk of reoffending. So that is why the state is asking for those 2 years in custody.
Got it.
That's all from the state.
Thank you. Ms. Bostic?
Yes, Judge. In regards to Mr. Moses, as the DA said, he has 48 cycles. He's currently mathematically on that probation for 20 SC 175-893, 5 years on the altering, forging counterfeit motor vehicle, and then 3 consecutive years on ID fraud, one of them, and then 2 on other ID fraud to count 2. And it was 20 counts total on that case. He also conviction for financial ID fraud, no insurance, driving without a valid license, and false identification with government logo or sale or seal of false statements in 2020. Another conviction for ID theft in 20. Theft by receiving stolen property, 2 counts in 16. And 4 other felonies more than 10 years old. FTAs in 24, and 23. History of probation violation. There's a hold for an FTA out of Noonan, 3/11/26. And he still has an open misdemeanor in Fulton, 21 CR 001091E for a simple battery. Nothing further.
Thank you so much. And thank you for helping out today. Appreciate it. You are good to go.
Thank you.
Ms. Simpson, Mr. King and Ms. Smith and I talked about this already. I know Mr. Moses was on probation and he was revoked a little while ago and is serving a year of that revocation. Does he have probation after that, or once he finishes his revocation, is he not subject to DCS supervision?
No, Judge, Judge Ingram revoked that 1 year and terminated the balance of his probation. So that sentence would be completed in August of this year.
Got it. Okay, thank you. Mr. King.
Thank you, Your Honor. I appreciate the time. First thing I wanted to, respectfully disagree regarding well, first of all, I don't disagree that the 2 years is reasonable under the circumstances from the perspective of the state. What I would disagree is the argument that the risk to reoffend, because he's not a violent man, because of even his past is not violent, at a certain point he's going to get out, whether or not the court agreed with the state or the defense or wanted to do something different. The state, he's going to get out of jail, and it's going to be up to him not to reoffend, because if he reoffends, then he's going to get less and less benefits of the doubt. Well, I wouldn't call this a benefit of the doubt, but less and less chances. So whether you give him 1 year or 2 years or 6 months, whenever he is released, he's going to have to not offend. But he will have the opportunity at a certain point. So I just don't agree with the argument of the risk to reoffend when these are not violent charges. And I haven't seen any time in the recent past, in the last 15 years, that he's done any significant jail time. So at this point, the lesson that may not have been learned, the lesson that should have been learned before, I think he's in a different situation. This man has received a year, and it looks as if he is going door to door that entire year. And from when he was given his adjudicated by Judge Ingram on August 25th, 2025, prior to that, he was in custody in the Fulton County Jail on the probation violation warrant from July 4th of 2025. So he's been in continuous custody in a situation in which, as I look back at his history, has not been at all for almost a year already. I believe this is a lesson learned, but I can't vouch for somebody that's not me, because I'm not the decision maker. He is. But he's about to be 67 years old, Your Honor. He's made obviously a ton of mistakes. And honestly, because I've gotten to know him and I really do like him, I don't mind saying this because I would say it to my brother. He hadn't been a good criminal recently, if you call it crime, because these are theft by receiving, and I really hold these in a different category than theft by taking. So what happens is somebody decides they want to sell him a car. And in this certain circumstance, he was approached by this woman that he gave the name to the police. And this woman was trying to sell him this car. And so he took possession of it, but not ownership. But I believe that if we went to trial, she also presented him with a copy of a title. If it was fraudulent, then it was fraudulent. But he was in the market to buy this car. He wasn't the one who stole it. So, and I understand the argument from the state. They used the fact that he wasn't able to contact the person that he gave, the name he gave. But in the police report, it says because the phone was dead. It wasn't because he didn't attempt to. He grabbed the phone and his phone was dead, and the police officer actually put it in the report. That was the reason why he wasn't able to contact the person they asked him to contact. I don't say that to say that I'm blindly arguing for his innocence today, because I'm not. I'm basically saying that in the grand scheme of things, he needs to do better, but he's done his year, almost his year. We're asking that the court give him that benefit, but I'm also asking for the court to give him benefit from July 4th when he actually got arrested, bonded out in October of 2024 for this case. But then the warrant popped and he ended up getting arrested on July 4th, 2025 on the probation, which was a result of this case. So he ends up being revoked, and he's done almost a year, but has to do the year to the 25th of August. And I do believe that's significant because he's never had to do it. I also believe based on his age, he has some severe health complications. He suffered based on that, not getting the proper care for his diabetes and high blood pressure, and he's gone down. And you know, some of it is just age, but a lot of it is because of him being in incarceration. I say all that to say, Your Honor, that I'm asking for this court to give him some mercy in the aspect of give him a 5 years to serve one. I would ask for that on this case, commute to time served. And he obviously still has to be in prison until the 25th of August. We're also asking that 5 years, the balance of the 5 years to be served on probation, Your Honor, with the condition that he pay a $2,500 fine, which would be hefty for somebody who hasn't had, you know, an opportunity to make any money since he's been in prison for almost a year now. Obviously, it can't be for a legal purpose, but if we're, as far as the way he makes the money to pay the fine, but if it were to be, then we'll be back here with another case. So, and I would ask that the court terminate his probation because as a 67-year-old man who has some health declines, as well as he has kind of proven himself to not be the savviest criminal. When I say criminal, I say in quotes because I think he's just a man who has made mistakes. But either way, he's going to be right back before somebody. Again, I don't think that it's necessary for him to be on probation because the only reason why you're keeping him on probation is if he doesn't commit a crime. Well, if he commits a crime, then that means you know about it. And if you know about it, that means he's going to be indicted again. So I don't see the purpose for probation. Now, if he was 20, if he was 18, if he was 25, I do see the purpose of probation for those things, for those situations, because some people need the behavior needs to be diverted. But in this situation, I believe is the behavior was diverted when he went to prison, which he hasn't been. So based on that, that's what I would be asking for from the court.
Got it. Thank you. Mr. Moses, I got a couple questions for you, and then if there's anything you want to add, you have the right to be heard. You don't have to add anything else, but if there is something, you're welcome to share that. If we rewind to October of 24, so the time when you got arrested driving this Macan, what line of work were you in?
At that time, I was unemployed.
You said unencumbered?
Unemployed.
Unemployed.
I was going through a very, very stressful situation. My diabetes was real bad, and I was getting amputations at Emory Hospital on both of my feet. And family members was dying. Didn't have anybody to support me except for I wouldn't call them friends, just the people that I know that was able to come help me get to the hospital, get around. It was just one of those periods that I was going through. And man, I'm still in need of amputations. Hopefully, if everything works out all right, I can get back on that. But yeah, I was spent a lot of time at Emory, 24, basically ever since 20, I would say 20, actually 2020.
Okay. Well, I'm sorry to hear bad health has taken that kind of toll on you. Is there anything you want to add? Or do you feel like Mr. King has laid it out there?
You know, basically, I just was being around the wrong people, you know, and depending on people to take me to the hospital back and forth, using people's cars. It's just been, it's been a trip, you know. I mean, like, everybody, I can't say everybody, but most of the people that I was dealing with was was involved in vehicles, stolen vehicles or whatever that I, had, used many times, to get myself back and forth to the hospital, driving without driver's license. It's just been a real nightmare for me, that's all. But I was able to, make myself available to the hospitals and to the doctors. I spent months at every university. I have an outstanding bill that's numerous. And the greatest thing about it is I'm still able to walk.
Good. I'm glad that they've been able to help you and you've started taking care of yourself some on that front. Well, Mr. Moses, I find there's a factual basis for your plea. The car you were driving on the 10th of October of 24 was stolen. I think Mr. King makes a good point that you had keys for it. It's a harder case for the state to prove. They might well, had this gone to trial, sought authorization from me to admit at trial some of the other things you've gotten in trouble for, which would educate the jury a little bit on how believable the claim is. I didn't know the car was stolen. But beyond that, you had a pocket full of fake IDs or real IDs that were fake, if that makes sense. It wasn't from an ID from Planet Mars, but there's your picture on a New York license without your name on it. Things that I call are badges of fraud that you had in your pocket, not that that the owner of the car had left in there. And appreciate you trying to palm some of the blame off on these people letting you borrow their stolen cars, but those IDs have nothing to do with anyone but you. So I think the state could prove up the case. I also find that your plea is knowing and voluntary. This is not your first plea. You know how these work. And when you have questions, you're good at asking them. And I think no one has forced you to enter this plea. So I will deem it to be voluntary. Ms. Smith, can someone in my office sign the plea, the indictment on your behalf?
Yes, Judge.
Mr. King, can we sign for you?
Yes, Your Honor.
And Mr. Moses, is it all right if we sign your name to the indictment indicating your guilty plea? We'll do that. The state has, for purposes of this plea, withdrawn the recidivist notice. So you are not being sentenced as a recidivist. The state is waiving that. I also appreciate Mr. King's argument about risk to reoffend. To me, I was hearing him say, you're not a violent criminal, although you have an open battery case. But that doesn't seem to be your MO. Your MO seems to be cheating and lying and fraud and fake IDs this and fake IDs that. I don't know that that means you're not at a risk to reoffend. You were on probation in the 2020 cases when you got arrested here with not one or two, but several fraudulent identifications. So to me, that's sort of proof in your pocket that you are a risk to reoffend in the way that you get in trouble. And I appreciate that you're not out there shooting people. We wouldn't be talking about, should it be 1 year or 2 year? But it is still something that leads to losses for others and is illegal. And you are at an age where you knew better. You've known better for a few decades now. And so if at age 64, that's how you would have been back when you were driving this stolen Macan, if you weren't getting it that it's time to knock it off then, I'm not quite sure why we think now you know any better. But I'm not suggesting that we have to then incapacitate you and say, we'll see it in 20 years. But you haven't made up your mind that you're going to stop whatever your hustle is. And I hear you about your illness, but as sick as you were, whatever that was in October of 24, you were still driving a stolen Porsche. Your story to the police is you were about to buy it. Your story to me now is I hadn't worked in 4 years. I don't know how you were going to buy a Porsche. And whatever money was in your pocket doesn't sound to me like it was necessarily clean money. You're going to need to figure out a way to roll in a different manner because it's just going to come back up again. And I'm not going to take Mr. King's invitation to say, well, there'll just be a new case as well. There'd be a new case while you are on probation. So I'm going to include probation as part of your sentence. Mr. Moses, I'm going to sentence you on count 1 to 6 years to serve 1 year and 6 months with a balance on probation. Your sentence is to count 2 is 6 years to serve 1 year and 6 months with a balance on probation. Let me break that down for you. That means 18 months. You will get credit. You're legally entitled to, but I also intend you to. So I'm making it very clear on the record. Every day you've been in custody since you were arrested in this case. That's 81 days in Fulton County Jail, plus all the time you've been in the Department of Corrections, because that revocation was based on this set of facts. So you've already done, you can do the math in your head, but pretty close to a year, if not more than a year of the year and 6 months that you need to do as a result of your conviction in this case. Then you'd be on probation for 4.5 years. That'd be your only active case. You've got this misdemeanor you're going to need to sort out in state court. You got to go to Noonan for a hold. I'm not going to impose a fine because I don't want you to have additional obligations. You got hospital bills that I don't know anyone is ever going to pay. But I want you to focus on that and obviously your health and not worry about a fine. You'll need to have no contact with the owner of the Porsche. It sounds like she's a complete stranger to you, other than you now know her name because it was in discovery. But she's someone who ought to be entitled to go about her life without getting any contact from you. So no fine, 18 months in custody, followed by 4.5 years on probation. That's less probation, actually less time than the state asked for. It's a little more than what your lawyer asked for, but because it's more, you and Mr. King should talk. He's going to give you the lay of the land based on this sentence that I've described. And you can let me know, you know what, Judge, no thanks. I'd rather go to trial. And then you'll stay put until we can get you in front of a jury. Or you can say, it's not what I asked for, but it's what I'm willing to take. And I'll sign off on your sentence. You can either get back to the Department of Corrections or to Noonan for that hold, and we'll move forward that way. Do you have any questions about anything I've said before you and Mr. King speak in private about your options? Great. Mr. King, if you will chat with Mr. Moses, and then I'll wait right here. You guys can come back and let me know the plan. So I think we can do the math, but I don't mean for you to do it. But Mr. Moses, if you look at his arrests in our system, he was in for 4 days on this case, then he bonded out. He went back into custody, I think it was in July of last year, but it's his second most recent arrest when he was picked up on a probation warrant and did 67 days here. That number's in the system. And that's when he then went to Department of Corrections on the revocation in connection with this, and he hasn't gotten out. He just spent 10 more days here because we did the production order. So he was saying July 4th, and I'll look right now, it's right here. He's been in nonstop. That's the easier way to do the math. Yeah, since July 7th. He was booked in July 7th of 2025. And there's a release date listed, but that was released to Department of Corrections on the revocation that was based on this conduct. So it's basically credit since July 7th of 2025. Which would mean he's got about 7 months left to do. No.
So motion to withdraw his plea.
Oh, yes. Ms. Rios is, well, I don't know if it's Ms. Oh, the one that Mr. Fryer represented. Yes.
Okay,
You're just reminding me.
Yes.
Yeah, I got that. I haven't decided if that's something Ben can do.
Oh, okay.
since we don't have other criminal stuff. What'd you go watch today?
Mostly Diggs.
Diggs?
Yeah.
That is taking longer than we forecast, and so Judge Emerson was supposed to start another trial on Monday. He tries to do one trial a week for the 2 weeks he's here. But he said that's at least gonna go into Monday.
Different chapter, same story.
Is that what it was today?
Yeah.
Yeah.
Can I run to the restroom real quick?
Yes, ma'am.
And I'll be right back.
You can go in the jury room if that's easier, whatever.
Forgot it.
That's gonna be a medical day already now. When that case closes.
Yes, yes. Have you been down there in 1D?
No, I'm with this concept, so I'm kind of used to them.
Yeah. Oh, it is. It's Judge Carnesale's case, so you know Diggs. Got it. You're a veteran. Yep. But exactly, it's gonna be, what is his name? Green? Who's your EMT on the sheriff's force?
Oh, yeah. Check to make sure he's here.
Yes, make sure.
Did you know I only went to Gwinnett?
I mean, you only went to Gwinnett.
Ione.
Oh, Ione went to, I did not know that.
Huh.
All right.
It's on that. I mean, I'm available. But yeah, I did my orientation yesterday.
Judge, quick question. If I really got for the 18th in arraignment, do you need us in person on that day?
Is it a game day?
I think it's one of our remote days.
Okay. The overarching answer is not unless, let me look at the calendars. I'm very open to virtual appearances. It is a game day, June 18th. Yeah, that's, I think, the South Africa game. But either way, that is a game day. So no, you don't need to be here in person.
Oh, I need to find out, yeah, isn't there a schedule of certain days we're supposed to telework?
So no one's supposed to telework, but you can. You would coordinate that with Judge Glanville.
Because there's like FIFA stuff going on or something.
Correct. We shared, and we need to get you a copy, a calendar that was really focused on when our jurors going to be here. But it has the game days on there, and those are days when there'll be no jury selection. The district attorney's office is trying to minimize the need for prosecutors to be here on game days, because in theory that's going to be complicated. Of course, the games are noon or later, but it still could be complicated. So,
So they suggest you telework on those days.
correct.
And so, yeah, that's what I meant.
Yeah, so yes, Ms. Smith, that's one where June 18th.
Yes,
Yeah,
that's gonna be hopefully in the morning and hopefully everyone will.
There's a jail Zoom calendar on the 17th also.
yeah, but that's a standard Wednesday jail Zoom calendar, and you're welcome. People are virtual for that if that's what you'd like to do.
Thursday, I'm hoping that most of the attorneys will file their arraignment waivers. And there won't be much, because it's just a PN, it's like maybe 14 cases or something.
But we'll be here in person for the, all of the trial calendar.
Good. I'd recommend that.
Maybe Tuesday.
Yeah, so the 18th, plea and arraignment.
Was Mr. Compton's sentencing squeezed in that week?
Mr. Who?
Oh, right, we need to do the sentencing for Kente Compton.
Oh,
Yes.
that's on Tuesday.
That's on Tuesday, the calendar call day, the trial calendar day. Right, I forgot about him. Yeah, so the defendants in theory will be coming in. So I don't know if Ms. Rios and Ms. Wood will be here, but they're a bunch of bond defendants and they wouldn't know other than through their lawyers to appear virtually, but because it's arraignment, they may not have met their lawyers yet. So we may have defendants coming in. That doesn't change the need for you. Again, I'm talking about the 18th, for you to be here. You're more than welcome to stay away. Hmm?
Looks like the speaker maybe proactive and they'll call them.
Yes, yeah, I agree. And it may be, we will have had 2 games already by then. And if those were complete disasters on the streets, we can be flexible about, hey, this person didn't make it, but it may be that they couldn't even get downtown.
Yeah, no more calendar.
What are you gonna do after that?
Judge McBurney.
Mr. King, let's get back on the record. Make sure we're ready. We good, Ms. Weaver?
Yes.
All right, we're back on the record. Did you and Mr. Moses have enough time to talk?
We have, Your Honor, and I've gone over the pros and cons, gave my opinion, and he has chosen to decline the plea and move forward toward the trial.
Okay. Mr. Moses, I'm not sure whether you'll stay here at Rice Street or be returned to Washington State Prison. But you'll know because you'll get put on a bus or you'll stay here. If something changes in your mind, because I'm not going to change what I think is a reasonable sentence short of trial. And so if it's been another few months and you do some math and say, wait a minute, let's just do this plea because I know what the outcome is, you should reach out to Mr. King. And then he can let Ms. Nelson know, let's just get everyone together again because you do the math. And if trial's not going to be until date X, then let's just knock this out. And I'll tell you, you're close. The math may be that you say, I'd rather do a trial and you bought yourself the 18 months anyway, but we'll see what happens.
Well, Your Honor, I don't see anything in the system showing that he would not be released to the street.
Well, we've got the hold out of Noonan. So he's going there.
Because he was in prison, so.
Well, I need to see what's going on in Noonan and see if that's a reason that there shouldn't be a bond in this case. I need to think through whether bond shouldn't have been revoked once he got revoked by Judge Ingram. So, like I said, the landscape may change and Mr. Moses may do a different calculation and say doing the plea makes more sense. Provided you don't get in trouble while you're in state custody, or if you stay here, you don't get in trouble on Rice Street, nothing will have changed. And so I'm not going to change and say, oh, you said no to what I thought was a reasonable sentence, so it's going to be more. So just keep that sentence in mind, because that's where we are. And like I said, you may decide getting the known of a non-recidivist sentence where you are parole eligible versus, of course, if you go to trial and you're found guilty of either of these offenses, whatever sentence you get, you'll do to the door, because you'll be sentenced as a recidivist, where you will be non-parolable. That's probably the biggest thing that would swing, because Ms. Smith made plain that she's withdrawing the recidivist notice only for a plea, because that means we don't have to drag the victim into court and officers and this and that. But if you go to trial, that recidivist notice is front and center. And so whatever sentence I impose, if you're found guilty, and it may be you're found not guilty, but if you are found guilty, whatever sentence I impose is to the door. So if I were to say, yeah, now that I've heard more after trial, it's 2 years to serve, you'll get credit for the time you've done, but there's no, hey, what about parole, early release? It would be until you're done with each day of whatever number you're sentenced to. But I'm trusting you thought about that when you said, no thanks to the sentence I imposed. Okay? All right. I'll get with my team about whether you stay here as in Fulton County Jail or go back to state custody, and let Mr. King know if you change your mind. Thank you, Mr. King.
Do you require this type of please be done or not?
No, ma'am. You have the takedown, and the world will contact you if they need that. All right. Well, thanks, Ms. Smith. We'll see you in a long time, because next week is civil.
Anything going next week?
Yes, a super exciting.
Condemnation?
No, but two people who went into business together to buy houses, rehab them, and flip them, and then financially it didn't go well. So
Is the process the same, still like picking a jury on Monday and then start with presentation?
if we pick the jury quickly enough, we actually start with openings on Monday afternoon. Civil juries are often, you have to qualify fewer because each side only gets 6 strikes. And so sometimes we can actually get rolling on Monday afternoon. Yep. Well, thanks. Thanks, Ms. Simpson.
Not a problem, Judge. I'll see you next week for drug court.
All right.